Okay, that's fine. We'll go ahead. And then the intention would be to go to Senate Bill 238 with Senator Meyer von Bremen next. Senator Hamrick, you want to come around?
Where do y'all put senators in this configuration?
The podium would probably be a logical place.
I don't like podiums.
Let me, I'm sorry, before you start, just for the benefit of those of you who are here, the chair is adding a bill to the calendar this afternoon, Senate Bill 34 by Senator Tommy Williams, and he's aware of that. So if anyone here has an interest in that, we'll be getting to that as we can around the members of his body's schedules. Okay, Senator Hamrick.
Thank you, Mr. Chairman and members. I appreciate y'all working with us on our schedule. And this Senate Bill 135 is legislation that the Recording Industry of Association of America requested because of problems in Georgia with music piracy. And we have a law, as you can see, at 16-8-60 that deals with this type of crime that was passed several years ago. And so we're just on page 2 adding some language and kind of clarifying what the penalty will be for violations of this code section dealing with the crime of music piracy. And I can get that crime further described to you by people in the industry. But as far as the legislation goes, starting on page 2, line 18, we are just establishing 3 categories. Currently there are 2. We add a third. In the first 2 categories, we're setting a minimum dollar fine and a minimum time of imprisonment. And currently there are maximum fines but no minimums, and there's no minimum requirement to serve any time. And so you can see there that line 20, the minimum fine we're asking for is $500, and the current maximum is $25,000. And also adding language that the sentence should include 24 hours of jail time. In the second paragraph, the minimum fine we're adding is $1,000, and the minimum prison time 48 hours. And then in the third paragraph, that's all new language, establishing a minimum and a maximum fine, and then a minimum amount of prison time of 6 days. Then the following section is a forfeiture provision to allow prosecutors to conduct forfeiture proceedings based on current law in terms of the procedure for forfeitures when they have a crime such as this, to be able to get the equipment used in the process of creating these counterfeit recording CDs or whatever it may be. So that's the other section there, and then the last part is a restitution provision to try to get some of the value back that the industry loses when these crimes are committed, and this inserts language to allow for restitution. Mr. Chairman, I have somebody here from the industry, and also Reagan Marsh is working in much more detail on this legislation and can answer specific questions if there are any.
Okay, questions from the committee for the author, first of all. Representative Abrams.
Thank you. I'm generally supportive of this bill, but I have a couple of questions about section, I think it's section E and F. I'm sorry, it's section F. On page 3, sections B and C, these are the forfeiture provisions. My concern is that there's no, how you would prove under section B that these assets were used to actually commit the reproduction. So, for example, if there's a computer sitting in someone's home that's a family computer, does that mean the entire family forfeits their computer because that computer may have been used in the commission of this crime? So my concern is that this is a bit expansive in terms of what can be forfeited by in relation to this bill. And under subsection C, it's again an offer of proof. How do you demonstrate that the property was purchased from the proceeds of this illegal activity?
Well, if you look on page 3, line 8, the procedure for forfeiture is the current code section 16-13-49, which I'm sure has requirements that you establish that the property you're attempting to forfeit has been used in the commission of the crime, and I'm sure there are some standards in there, and I would ask if the committee would allow for Reagan Marsh to elaborate on that. He has experience in this area and has researched this law, if we can. Can I ask him to help answer that question?
Sure.
Representative Abrams, it's a question of fact, just like any other criminal charge. To use your example, if someone is found making these CDs and they go back to their home and there's a home computer there that everybody in the home obviously uses, you're going to have a hard time proving that was used to make these fraudulent materials. However, if you hit the eject button on the player and the fraudulent CD comes out and the software is on there to make it, and it's surrounded by these fraudulent CDs, I think you're getting a little closer to having a better case. So like with most criminal charges, it is a question of fact.
Spoken like a former prosecutor.
I got a question.
Vice Chairman Mumford.
Mr. Hamrick, I'd like to draw your attention to the punishment sections in here. At line 22, it says first offense, judge can do a bunch of stuff, but he's got to give him 24 hours. In line 27 for second offense, it says he's got to give him 48 hours. In third offense, it says he's got to give him 6 days. Doesn't that kind of devalue this situation? I mean, I would think some judges would find cases where they would want to throw people in jail for a long time. You know, you catch a guy with $1 million worth of merchandise. Seems to me they might be headed to prison on numero uno, and it just sort of, it sort of violates my principle that I think our judges, I'm not allergic to Superior Court judges, I think that they ought to have discretion. I just can't imagine why it's suggesting that 24 hours, as if they, they're just going to let him go, so we're going to show them and order them to give this guy 24 hours in jail. I mean, excuse me.
Well,
is that a question, I guess, is your question?
You're the former judge. I mean,
That's a good question. Is that a question?
Is it true?
What's the thinking there, I guess?
Can I get... we've got somebody from the industry here, and this is a bill that they've been working on in other states, I believe, and we could probably give you some justification for that if I could defer to Aaron Aguilar. Would you?
Well, they need to know that we give more time for DUI in this state than that.
Not yet, but we're working on it.
Representative, this is an approach.
Not real hard.
This is an approach that they've taken in other states that they've seen good results with, and it may not be right for Georgia, but this is what they've seen good results with in the Northeast, and so that's why it was suggested for this state also. I understand your concerns on it. 24
hours in jail? I mean, what's that supposed to do?
Well, it's supposed to show someone who's caught for a small-time offense that is serious, and maybe try to convince them not to do it again and move on to larger fraudulent activity.
I think part of it is that this is a crime.
I don't know what county you come from, but where I come from, you get arrested, you're going to spend 24 hours in jail before you can make a bond in all likelihood.
I think this is a crime where the person committing it is out to make money, and so the consequences a lot of times are just the cost of doing business, whether it's probation or loss of proceeds. And so the idea is to, I guess, to give them give them some jail time and make them realize that they can make money and move on, but they're going to have to suffer a little bit more serious consequence than just the monetary part of it.
Thank you.
Further questions from the committee? Further questions from the committee? Okay, Representative Lunsford.
Senator Hamrick, on page 2, I've got a question, and I'm just kind of curious on this. We get into line 4, and we talk about what is unlawful for any person, firm, et cetera, and it gets down further into the thing, and it says on line 9, unless the address of the transferor of the sounds or visual images in a prominent place in outside face or package. So basically what we're going after, I guess, is a person who compiles the disc with multiple songs or multiple things, because then, of course, you couldn't compile it all on the front of the package. If you had 20 songs where you burned your own 20 CDs into one CD, is that the whole take? Because the way I'm reading it, please correct me if I'm wrong, if we go down to line 16, it says solely for the personal use of the person transferring, but without any profit being derived. So in other words, with this bill, I could actually burn those songs and give it away, but I couldn't sell it.
Well, you're talking about current law, so I mean that's not something we're adding. That's the statute
I
now.
I'm just asking a question. Does that make sense?
You're gonna have to either rephrase it for me, or I'm gonna have to get some help on it. I'm not sure I understand the question.
I mean, in other words, if I burned the songs on the CD and I didn't sell them, I gave them away. Under current code, am I?
No, sir, you're not committing a crime.
Okay.
This is for folks who make profit.
No, I understand, but does that really actually make sense that we would allow them to burn it for free as long as they don't make a profit and keep them and give them away? That was really the question. I'm just kind of curious.
Well, that's not. You understand that's not what we're trying to do. That's what the legislature did before I got
That's
here.
why I said it was just a question.
Representative Levitas.
I feel more comfortable about my teenagers now.
Mr. Chairman, I think with my utmost respect for my great colleague, the Senior Hawk, I believe that this would be solely for the personal use of the person transferring. If you gave it away, that would no longer be for the personal use of the person transferring or causing the transfer.
That's what's true. Thank you.
Further questions? Chairman Franklin.
Thank you, Mr. Chairman. Back on page 3, the first 4 lines there. A concern is, and I do like the bill. We don't want to encourage people to be violating copyrights and stealing this intellectual property. But let's say we've got somebody here in Atlanta, and they just bought a bunch of mass duplication equipment, and they've installed that in their basement. And what they're doing is they're working for their church, duplicating the pastor's sermons and getting them distributed all over the place, and UPS or whoever comes by every day, and out go all these CDs. Somebody thinks that a crime might be taking place. Somebody's duplicating a lot of CDs over here. We don't know if they're legitimate. And lo and behold, in the middle of the night, and by the way, the person making these things is about maybe 80 or 90 years old. The police come in the middle of the night with their no-knock warrant. They bust down the door, and then they see this duplication equipment, and as part of their raid, they haul that off and seize it. Obviously, no crime had been committed other than possibly the breaking down that door. I'm concerned that now we go through the whole civil forfeiture. This 80-year-old woman's got to now go sue to get her equipment back when it's discovered after the raid and her property was seized that that was really legitimate stuff. We got a bad tip. How would you address that concern?
Well, I think I would say that how our laws, or any law we pass, is carried out and enforced is up to the people that are there in whatever jurisdiction it may be, and making judgments on their own. I mean, we, in the case of we set the framework for how you get a warrant, but we don't execute the warrants and decide whether it's no knock or knock. So to a certain extent, we have to rely on people who enforce the laws and make judgments on them. And all we can do is give them as much guidance as we can, and obviously they don't always live up to the standard we like for them to. But I would hope that would not happen based on the judgment of the person who would be making those decisions.
Thank you.
Representative Levitas.
My question is a little bit different. I actually don't mind the forfeiture statutes that exist in the OCGA or in this code section as proposed. My concern is maybe with the drafting. As I read F1A, beginning at line 36 and 37, as opposed to subparagraphs B and C on the following page, it seems to me that you could be subject to forfeiture just for transferring anything. Not in violation of the code section, which is referred to in subparagraphs B and subparagraph C, but in A, which doesn't make that reference. If you just do any kind of transfer for any reasons, you'd be subject to forfeiture, is the way I read that.
Reagan, do you see where he's talking about?
Quick amendment to this bill to fix that line.
Okay. I assume that would be to author and to his valiant help here. Well, I assume that would be a friendly amendment to fix that, just to make it read the same as the other. I think if you don't, you're asking for some real problems, and probably going to get a few no votes you may not pick up otherwise. I'd be real concerned if we were going around saying anybody who makes any transfer of anything is subject to have their property forfeiture. I support this bill. I'm just saying I think as it's read, that particular paragraph leaves you open to forfeiture for anything, for making any kind of transfer, legal or otherwise. So at the appropriate time, Mr. Chairman, I'd like to be recognized for a motion.
I'll come back to you. Is there any further questions from the author? Any further questions? Recognize Representative Levitas.
Thank you, Mr. Chairman. I would propose to amend line 37, and in between the word transferred and the semicolon, insert the words to commit a violation of this code section, with code section, the word code being a capital C. So that the whole subparagraph would read, any phonograph, record, disc, wire, tape, videotape, film, or other article onto which sound or visual images have been transferred to commit a violation of this code section.
You're offering that in the form of a motion to amend. Is there a second?
I think you accepted it. I think it's off at second.
Well, I'd like to have it a motion. You second it, right? All right, we have a motion to amend by Representative Levitas, and that the author does accept that amendment?
Yes, Mr. Chairman.
Okay. Yes, Representative Abrams?
Can I actually
discussion on the motion now.
I would like to offer a friendly amendment to the amendment. The way it's phrased right now, it doesn't quite.
Do I need to be cutting some deals on whether I accept the amendments or not?
This is just stylistic as opposed to.
I should have warned you about bringing forfeiture issues to this committee.
I'm sorry, I didn't mean to interrupt you.
Oh, it's quite all right. I would just, instead of saying to commit a violation, I would say in violation of this code section.
I'm sorry.
So instead of the phrase to commit a violation of this code section, instead I would recommend that it say in violation of this code section. Because it's the transfer that's.
And would accept it if
You withdraw your.
I will withdraw my amendment and let the Abrams amendment, which always has a greater likelihood of success anyway, be proposed.
She's doing pretty well. Is quite a compliment there.
It is.
Is there a second?
Second.
All right, Levitas seconds the new amendment by Representative Abrams. Is there, and the author accepts that one?
Yes, sir.
Okay. Is there objection to the Abrams amendment? Hearing none, it will be adopted. Any Representative Franklin, Chairman Franklin?
Offer an amendment.
Okay.
I move that we, on page 3, strike lines 1 through 4, which would probably mean we would need to get rid of the number, the letter A, back on line 36 of page 2, just to have the punctuation correct. That gets rid of the forfeiture if you haven't been found guilty.
I'm just trying to see how that would now read under your amendment. First of all, is there a second to the?
I've got a question. I don't understand it. I
No, we don't. We're not really at a posture of discussion.
Second.
All right, now we are. Let me first of all understand the amendment. You're proposing to delete lines 1, 2, 3, and 4 at the top of page 3.
Yes, sir.
Okay, Jill, help me out. We would then renumber on line 35, page 2 as F1. Would we also then take out the A because we would not need that?
Correct.
And go directly to?
Except on line 5.
Okay.
You take out the colon at the end of line 35 on page 2.
Okay. If there's no objection from the committee, I'm going to state the Franklin amendment as actually striking the word A on line 36 of page 2, and then deleting lines 1, 2, 3, and 4 at the top of page 3, and that's where we are. Yeah. Sure.
Actually, the way F1 reads, it says the following properties shall be subject to forfeiture to the state of Georgia. So if you were actually getting rid of,
Yeah, we're only having one.
probably should just say, begin on line 36 and say any photograph, etc., through violation of this code section shall be subject to forfeiture to the state of Georgia, except that no property. In other words, merging F1 into the sentence.
What about F2 on page 3, lines 8 and 9 would?
Still, the F and the 1 would still remain.
Okay.
It would just begin with any phonograph.
Okay.
Do you want me to read it out loud?
So we're taking out the following property?
Right.
Okay.
And shall be subject to forfeiture would come after code section.
And I'm going to ask Jill to read out loud where I think we are on the Franklin amendment, just so that I'm not asking the author to agree or the committee to agree, but simply be sure we have an understanding. Jill?
Any phonograph, record, disc, wire, tape, videotape, film, or other article onto which sounds or visual images have been transferred in violation of this code section shall be subject to forfeiture to the state of Georgia, except that no property of any owner shall be forfeited under this paragraph to the extent, and I'm picking up the language on line 6.
Is that an accurate statement?
That's very accurate.
All right. First of all, before discussion on the amendment, any question about the technical part of the amendment? Vice Chairman Mumford, you may have forgotten your question, did you?
No, I've just managed to answer it on my own.
Okay. That's what I was hoping you would do with that.
I had some help from
delay.
Mr. Beard.
Good. Good.
Answer
All right. We have a motion to adopt an amendment offered by Chairman Franklin. Were you wanting to be recognized?
For a question.
Okay, Representative Levitas.
This is to the author of the amendment. Though, again, I don't know that we share the same belief as to what is currently lines 1 and 2 on page 3, striking those. What is the concern of the author with regard to property that constitutes the proceeds derived or realized through a violation of this code section? If the prosecutors are able to determine after proof to the prior fact that the property constituted proceeds derived or realized through a violation of the code section, I was wondering what the problem is that the author's amendment is trying to address by striking that particular subparagraph.
I'd be glad to respond, Mr. Chairman.
Have at it.
It's that in the scenario that I mentioned to the senator, someone might think that you are in violation. You haven't been convicted. You might it'd be similar to if someone were in the nursery business from Atlanta. They have $20,000 in cash on them. They go to the airport, buy a one-way ticket to El Paso to pick up a bunch of plants and rent a truck to drive it back. The fact that they bought their ticket with cash and it's one way, that put all sorts of flags on them. They land in El Paso, they'd be surrounded by agents who seize their cash. They haven't committed a single crime, and they never get their money back, and they're not even arrested because they're suspected that that money was used illegally. Why would someone be carrying that amount of cash? It's that same time, and that's the cities might be wrong, but that's a true situation that happened. The situation is here also. No court has rendered a verdict that any proceeds, any equipment was used in the commission of a crime. And until that time happens, you might be an innocent person that just likes to have a lot of equipment in your house. You've got a lot of duplicating equipment. You might, like I said, you might use in your church, and you have some nice things in your house. They might assume that you use those from selling illegally duplicated recordings when everything in your house is legit. But they make that assumption and start hauling off all your stuff, and now you're not going to get it back because it's been forfeited. That's my attempt to answer why I want to get rid of paragraph C.
Representative Levitas.
And I guess my question is how this would differ from any scenario wherein the police or another law enforcement agency suspects someone of committing a crime. In other words, the very fact that an arrest is made is based, or is supposed to be based, of course, on the articulable suspicion that a crime may have been committed. And so the purpose, as I understand it, of the court would be to hash that out, have the opportunity for the day in court. But I guess if we have the same concern for people as you would be raising the property, then we might not be arresting people just because their suspicion is a reasonable suspicion, because there might be the possibility that that is in fact lawfully possessed rather than criminally possessed property. And so, again, my concern is, are we erring on the side of never confiscating property because of the chance that there may at some point be some property confiscated that should not have been?
If I could respond to that, Mr. Chairman. Since it's forfeited on lines 8 and 9 under the current provisions in the code, that I do believe is where we have a problem. And until we fix that, then we need to be more concerned with the criminal than property. And I would love to work with you and try to come up with a good way so that when a person is convicted, they lose it all. But until they're convicted, their property, their family's property, isn't the criminal. And then when they're found to be innocent, or they said, "Oh, we got the wrong guy," or and so charges are dropped, or they are found to be not guilty, they've already lost their property, and that's the problem.
Thank you, Mr. Chairman. Thank you, Representative Franklin.
Okay.
You're welcome.
All right, we're on discussion on the Franklin Amendment. Any further discussion on the Franklin Amendment? Any further discussion? All in favor, or what? Yeah, all in favor of the Franklin Amendment, please indicate by raising your right hand. You got it? All opposed? 3-3. Chair votes to break the tie in the negative. Representative Bearden, you wanted to be recognized?
Yes, sir. To the senator, and more importantly, my senator, I'm not trying to make this process any more difficult, but I'm looking at these sentences, and anyone that's known me for over, say, 30 minutes know I'm a mandatory minimum type person. But these numbers on here is just so low, especially for the third time. It's only 6 days. And no disrespect to no one, but I almost feel like that's a joke towards mandatory minimums. I would feel better if they were just stricken out and given the discretion to the judge. Because if I was a judge and looked at it, I'd be like, well, that's all they think it's at least worth. That's all I would do. But
scary thought, you being a judge.
It would be a hangman's judge, I promise you. But I just look at it, I just would feel better if that was taken out and gave it to the discretion of the judge instead of putting these very low minimums in here. Would you accept that?
Why don't? Well, I mean, I think that's an important part of the legislation. That's one of the main reasons that we're doing it, and I think it's important to have that in there, and so it on the one hand, it's not a lot of time, but on the other hand, it's some time, and if we strike it, then kind of takes away some of what we're trying to do here. But if we add more time, then you get into more of the problems of mandatory minimums, and so I think it's just a good balance between something but not too much. I mean, it's not like we're going to clog the jail system up with people committing this crime because we're creating these mandatory minimums. They're small enough that it's not going to have an impact on our correctional system, but it may have an impact to help accomplish the goals we're trying to accomplish.
To save me in my district, when stuff comes to him, I'm going to go ahead and let that go and accept it when that's what he says. So I'll leave it alone.
Chairman Franklin.
I'd like to be recognized for another attempt at an amendment. On page 3, line 15, I think we need to be grammatically correct, change the word restitutions to restitution. So I would move to drop the S on the fourth to the last word in line 15.
Jill?
Yeah, I think it should be restitution.
Okay. Any objection to that amendment? Hearing none, we're going to adopt that one. Thank you, Chairman Franklin. You got one.
I accept that amendment.
Further discussion. This issue was never a problem in 8-track days, was it?
I don't remember those days, but
Well, I do.
No, I do, Mr. Chairman.
Life was simpler. Representative Levitas.
Mr. Chairman, I had a question for the author or the expert on this one. Can you just tell me what that entire last sentence means, lines 15 through 19? I just did not understand the part about the whole aggregate wholesale value of lawfully manufactured and authorized recorded devices corresponding to the non-conforming recorded devices involved in the violation of this code section. I just have no idea what that means. I'm sorry. I mean, I may be the only one, but I just don't know what that means.
Representative Viz, this is a way to deal with intellectual property and deal with restitution that when intellectual property is taken. Basically what you do is you take the amount of the legal items and multiply that by the wholesale price of those.
Okay. Is that what that means? Okay, great. Thank you.
Further questions? Further questions? What's the pleasure of the committee?
I have a motion.
Vice Chairman Mumford.
On page 3, line 3, strike the word any after C and put only property constituting proceeds derived from or realized through a violation of this code section.
Okay, we have a motion. The Mumford Amendment. Line 3, page 3. After the word C, strike the word any, substitute the word only. Mr. Author, you want to confer with your advisors?
We're okay with that one. Mr.
Okay.
Chairman.
Is there any objection to the adoption of that amendment? Hearing none,
I don't have a problem with it.
okay. Hearing none, that amendment is adopted. Further discussion? Again, what's the pleasure of the committee with respect to Senate Bill 135? We have a motion. Do we have a second?
Second.
We have a motion. Senate Bill 135 as amended, or is that by committee sub as amended, be given a due pass recommendation. Is there discussion on the motion? Is there discussion? All in favor of...
I have some discussion.
Vice Chairman Mumford.
I love Senator Hamrick, but I'm just not sure this bill's ready, and I'm going to vote no. There's a lot of problems with this bill.
You have that right. Is there further discussion? Further discussion? All in favor of Senate Bill 135, be given a due pass recommendation by committee sub as amended, please indicate by raising your right hands. Did you get with this? Okay. All opposed? 4-2. Are you voting in opposition? 4-3. The motion has been adopted, and that will be sent to the Rules Committee appropriately.
Thank you.
Take care of your business for the moment.
Yes, Mr. Chairman, I appreciate it very much.
Thank you very much. Did you? I'm sorry, Chairman Franklin. Were you asking to be recognized? Oh, I'm sorry. Okay. All righty. Senate Bill 238. I think I saw Senator Meyer von Bremen. Yeah. Sorry, Senator, you're in the dark back there, and I couldn't spotlight you. Come on around, please.
Thank you, Mr. Chairman. Senate Bill 238, and I appreciate the committee putting this on the agenda. This legislation corrects something that we passed about 4 years ago that, by oversight, we left in. The original bill that passed a few years ago provided that if someone tampers with evidence or destroys evidence that was that dealt with the commission of a crime, that it would become a felony to do that. There was a very, very bad problem throughout the state with individuals destroying the evidence that was the key component to a prosecution. And they knew that the only penalty back then was a misdemeanor, so they felt like, well, what's the big deal? I'll go ahead and get rid of it, and if I have to get 12 months in jail, that's basically what will happen. A few years ago, we increased that to be a felony, and when we did so, the legislature passed the law. We left in language that says it involves another person. In other words, it has to be destroyed by another person. Didn't take long for someone to catch on that they could destroy their own evidence against them, and as a result of that, they would only be prosecuted as for a misdemeanor because they are not another person. It's them. It's themselves that. Excuse my language. I can't get it right today. I'm doing too many bills. But basically, this is saying now, if another person destroys the evidence, or if you destroy the evidence that pertains to your case, to your prosecution, then you can be prosecuted for a felony, and corrects that oversight.
I don't practice criminal law. When does an item become evidence? Is it if I'm being chased and I throw it out of my car so that you can't connect it to me, is that tampering with evidence, or is it only once I'm in custody and there's a case pending against me that those items then become evidence?
I couldn't answer that either because it's been about 25 years practicing now, 15 years since I did criminal cases. Anybody here at the prosecutorial clinic? They were going to be. But I couldn't answer that. I know a case in South Georgia where 2 duffel bags of marijuana disappeared in a prosecution of a case. And you can only imagine without the 2 duffel bags what kind of case it became.
Right. I guess my question to my colleagues is it if it's evidence once there's actually a case pending versus before you can actually make a charge? That would be my. Kevin,
I'm going to call on Vice Chairman Mumford, who was looking away.
Using the marijuana example, if I toss the marijuana out of my car while in pursuit and you can't actually tie it to me, is that?
If you're asking me, are you subject to being charged, you better believe.
No, not subject to being charged. Am I subject to being charged under the statute?
Yeah, that's what I'm saying. Yeah. The police will charge anything that they can reasonably. It's like throwing mud on a wall. You just throw as much mud and see how far it'll go. And if throwing it out the window is tampering with it, they'll charge you for that.
Let me talk to Judge Mumford. Would that charge stand in your court? Okay, well, you're the problem. You're the wrong judge.
Yeah, I'm the problem. Yeah. Possibly, very possibly, it could stand up.
This also, if I may
classic
point...
case, if you'll...
Excuse me.
The classic case of tampering with evidence is, I had a case one time where a guy got stopped and the police officer took a bag of cocaine out of his pocket and put it on the hood of his car. And the guy bent over like one of those birds, that has the little thing in the back that makes the beak go down. And he ate the cocaine off the hood of the car. And he got convicted of tampering with evidence. He didn't get convicted of violating Georgia Controlled Substance Act, however. So that's what the senator's bill is going to ideally.
And it does, for clarification, it's a felony only if the underlying charge is a felony. It's a misdemeanor if the underlying charge is a misdemeanor.
Of course, in the case of some disappeared cocaine that you don't really know what it was, what is it?
I think cocaine is probably by definition a felony.
Well, except if you don't have it to test, you don't know what it was.
That's true. Well, then you don't have a case, I bet.
Secretary Bearden, were you trying to be recognized?
I think he was trying to leave.
No, I was taking exception to throw the mud up on the wall as much as you can.
You were trying to do harm to him. Representative Levitas was, I know.
And I know you were going to try, but I'm still here. Mr. Chairman, my only question is I really don't know the answer to that question, except that theoretically evidence is something that's only been ruled as admissible by a judge, and so I don't know the answer to that. I don't know if Judge Mumford would have a different view on that, but I don't know that it's evidence until it's been admitted as evidence.
Well, it's admitted evidence then, but I'm not sure that I would.
I just don't know what the answer to that is.
We talk about evidence,
right?
And getting our evidence together prior to a hearing or a trial. I mean, is there a big distinction in the law between proposed evidence and admitted evidence? I mean,
I don't know.
I'd like to ask you a question.
Yeah, Representative Abrams.
Oh, no, I was just saying I'd like to ask easy questions.
Oh, yeah. Since when? You ask good questions, though.
I've got a motion in the appropriate time.
Vice Chairman Mumford.
I'd move to pass on this.
Is there a second?
Second.
We have a motion that Senate Bill 238 be given a due pass recommendation. Is there discussion on that motion? Is there discussion? All in favor of the motion indicate by raising your right hands. 1, 2. 1, 2. Keep them up if you're going to vote for it. All right. All opposed. Motion is carried. Thank you very much.
Thank you, Mr. Chairman. Appreciate it.
Appreciate your hospitality this morning, too.
You got it. Thank you.
All right. Got a couple of little bills left here. Do you want to do 91? Okay. we're going to take up, it's not on the agenda, but it should have been, and that's Senate Bill 91 by Senator Pearson, was before this committee yesterday, I think. Representative Lunsford had agreed to work with the senator on his bill. He's not here. You want to take a shot at it?
Yes, sir, Mr. Chairman, members of the committee, I appreciate that. I think most of you were in the hearing when we were talking with Senator Pearson. And Senate Bill 91 had to do with fleeing or attempting to elude a police officer. And there were some concerns in the committee when we talked about the fact that the offense was at a greater level than current DUI law. And what are we saying then? That you'd be better off to be drunk and stop, I guess, than try to outrun a police officer in the second offense. So at the discretion of the chairman, he asked myself and Mr. Mumford to work with Judge McGarity, who was in the committee room, to come up with some language that would be a little more palatable and put it back in line with current Georgia code. And so the recommendations from the judges who looked at it were pretty simple, and I'd be happy to go over that with some of the people if they know. And they were fairly easy amendments to bring it all back in line. And the first amendment that we came together on was on page 1, line 22, where originally had the upon conviction, meaning the first offense only. Yes, sir.
That's probably true. I don't think they're in the folder.
They may not be, Mr. Chairman, because we did yesterday.
Why don't we suspend and...
yes, sir.
Excuse me? Okay.
That'll be fine, sir.
Let's suspend until we have copies. I think where... This was left out. Okay. Let me ask the committee if you have in your folders, and this is a bill we did this morning, Senate Bill 182. Jill just pointed out a very minor technical problem, but I like for our work to be perfect, and at least technically. Do y'all have copies of that bill in your folders? Okay. Looking on page 3, line 29, was line 29 omitted?
Well, when we went through we took out that as amended language, as amended from time to time. We took it out on page 4, we took it out on page 14.
We need to take it out there.
23,
okay.
But I missed it in one location.
Okay.
It's on page 3.
Okay. And I was not there for that discussion, so.
I'd make a motion to take it out.
Okay.
To perfect the
Is there objection? Is there objection? Okay. We have a motion that's going to be adopted without objection, that on page 3, line 29, that we strike that line in its entirety, correct, Jill? And put a period at the end of line 28. Okay. Thank you very much. Let the record reflect that. That'll save a floor amendment. All right, we're going to hold 91. Is Senator Williams coming over himself on 34?
Sir, he's right now in the Education Committee presenting another bill, but I'm prepared to present on that.
How long will he be there, do you know?
No, sir, I can find out right now.
Okay. Tell him I'll make a deal with him. If I can send my aide to do a bill in Senate Judiciary right now so we can keep going, I'll be glad to hear from you. Okay? If you'll communicate that to Chairman Smith, and if not, then we'll have to do something else. I'm sorry? $145? We've already done 145. Huh? Reconsider 145. We finished with 145. Yeah, he's checking. No, I know we added that. Call Daniel and. Okay. I wanted to have a short break before we did 205, and I suspect 276 may take a few minutes, but maybe not. How long will he be in getting here? Okay. All right, let's take a 2 or 3 minute break. We'll stand in recess for 2 or 3 minutes, pending the arrival of Senator Williams, and then I'll have some discussions with others here. We are going to, Senator Williams, if you can hang with us just for a moment. Mr. Leader, if you can hang with us just a moment, we're going to get our Hawk over to, or get Representative Lunsford, rather, over to another committee meeting.
Thank you, Mr. Chairman.
Senate Bill 91, you all now have copies of that.
Yes, sir, and there was some consternation with the committee on some of the verbiage on this, and you had assigned myself and Representative Mumford to work with the judge and the author to fix some of the concerns. And we came up with only about 6 words and a strike, and I'm hoping the committee would agree with this. And the concerns with the judges were we'd taken out their flexibility and we'd impose punishments that were more severe than a DUI for a second offense. And so what we did was on page 1, line 22, where it said upon conviction, in between upon and conviction, we put in first or second conviction. We would go back to current Georgia code, so nothing would actually change there at all, except that would just stay the current code even for the second conviction. But then on page 2,
no, we don't have a sub. We're working from the original bill as it came over from the Senate.
I apologize.
And well, did you draw a sub?
Pardon me?
You didn't draw a sub?
No, sir.
No. We're working from the bill, and Representative Lunsford, as I understand, after conferring with Senator Pearson, is going to offer some amendments to this.
Yes, sir. Thank you, Mr. Chairman. That's the instruction of the chair yesterday after we met. But on page 2, line 1, it has any person, on line 2, where it says second, we would strike the word second and put third or subsequent conviction. So that would have to be their third conviction. And then on line 10, where it says guilty of a felony punishable by a fine of $5,000, the wording we would change it to is a fine of between $1,000 and $10,000 and give the judge the discretion to impose the fine. So we've actually made it a stiffer penalty, but based on the circumstances, the judge could adjust it as he felt needed. And then on line 11, behind the period, we would offer the amendment where we strike the word following and strike everything to the end of line 15. So basically what we've done is given flexibility back to the judge, and we haven't given a mandatory sentence that he must impose. And the concern that we had during the conversations were that if a person had 3 or 4 offenses, the judge would feel a little obligated not to punish them for some of their true offenses, but to punish them for this one offense because it had mandatory sentences and it was a greater sentence and punishment than the other ones would have been. And we could have ended up with what could be concerned as stacking, or otherwise could just be a little too severe a punishment for what the crime actually was. And that was the consensus of the small subcommittee, Mr. Chairman, that you put together. Of course, it's the will of this committee that matters most of all.
Absolutely.
If they agree with that.
All right. Does everyone understand the proposals that are being tendered or requested by Representative Lunsford? Are there any questions?
Jill doesn't.
Yes, Jill.
And we strike out all the inflexible language for the presiding officer.
Okay. Now, Chairman Franklin.
Is that a motion that he has made?
Not at this time.
Not at this time.
I just want to be first want to get us on the same page in terms of understanding the changes that have been made. Does anyone have questions about the changes and what that have been proposed by Representative Lunsford to Senate Bill 91? Now, hearing the proposed changes, what's the pleasure of the committee?
Move to adopt the amendment.
Okay. Is there a second? We have a motion to adopt the Lunsford amendment to Senate Bill amendments to Senate Bill 91. Is there any objection to that motion? Any objection? Hearing none, the Lunsford amendment is adopted. What's the pleasure of the committee with regard to the bill?
Move to pass by committee substitute as amended. Second.
We have a motion that Senate Bill 91 be given a due pass recommendation by committee sub as amended. Is there any discussion on that motion? Any discussion? All in favor of the motion, please indicate by raising your right hands. All opposed? Senate Bill 91 has been given a due pass. You can be. Thank you very much. Senator Williams? We're on Senate Bill 34, which has been added to the calendar and should now be in your folders.
Thank you, Mr. Chairman. And you should have a substitute. About 10 minutes ago, the screw fell out of my glasses and the lens as well, and I cannot see the document in front of me, but I'll do my best.
Can you see if we're voting for or against you?
Oh, I'm in good shape now, though.
All right, good. Are we working off LC 350537S?
Yes, sir.
All right. Everybody, hang on one second. Everybody got that one? Levitas? Representative Levitas, have you found your copy? We might want.
Here you go.
Are we together now? Okay.
Thank you, Mr. Chairman. This bill comes to me from a warden in one of our private prisons who was formerly the warden at Georgia State Prison. And he simply said, Senator Williams, I've got a problem I need you to help me with. We've got prisoners who've created sexual acts and are in prison for rape, for molesting children, for murder and whatnot, and they are able to obtain for their own personal use the photographs of their victims, and we need the ability to take that away from them or not allow them to have it. So we've drafted the bill. The bill has the substitute actually allows for the Part B there, which allows for a person who's committed a crime against a person, something other than a sexual nature, would be able to have, say, a picture of their wife, even if there was an abusive relationship. So the governor's office has asked us to put that in there. But basically, the GBI supports this bill. They get open records requests at all times from prisoners, and this is something other than for what they would need to defend themselves in court in an appeal. This is for their own personal sexual gratification, and frankly, we don't need to allow them to have it for those reasons. There was questions previously regarding the First Amendment, and we asked Ledge Council to look in that. They found some case law which would back up SB 34. So we've done our homework there, and happy to present that to you, Representative.
And this came through one of the subcommittees. Was it yours or?
It did.
Okay.
Got a due pass recommendation.
Okay. Thank you, Mr. Leader. Are there questions of the author on Senate Bill 34?
Sorry, but I do.
You have questions?
Yeah,
okay.
I'm sorry. I'm sorry, Senator. Can you tell me? I heard you talk about allowing the inmate to possess a copy of a photograph of the inmate's spouse. Is it what code set? What part of the? What
That's
subsection?
Chapter 5 of Title 16. which is crimes against a person. But for somebody who's violated Chapter 6 of Title 16, it would be strictly prohibited.
But we want to allow the abusers to have photographs, just not the sexual predators?
And if you look at C, an inmate who is serving a sentence for violation of Chapter 6 related to sexual offenses shall be prohibited from possessing or carrying about his or her person or maintaining in a prison cell or similar area under his control any photograph, picture, or similar depiction.
Right. And I'm sorry, can you help me understand, and I just don't know the chapters and titles right off, what is Chapter 5? Is that violence, domestic violence?
I'll let one of the attorneys here.
So if it's a crime against a person, I guess what I'm trying to, I agree 100% with this. I'm just trying to figure out why we want to be a little more lenient when there's crimes against the person's victim. I'm somewhat unsympathetic, to be honest with you, whether it's the person's spouse or not their spouse.
Well, the way you're posing the questions is how I had the document written in the first place.
Mm-hmm.
But the governor's office has asked us to put the language in here that protects someone who's not created a sexual act to have a photograph of their wife or family.
Even if they made a career out of beating them up?
Well, I guess they're considering that a photograph of your wife that's something other than the photographs of the victim when the act took place, that would be appropriate.
Okay. Thank you.
Further, I'm sorry, Chairman. Chairman Nuts.
Isn't there already, isn't the law already that the person who's in custody essentially gives up most of their civil rights, and that doesn't the warden of the prison have a right to say what they can have in their room, what they can't have in their room?
To a great extent, contraband is prohibited, and they can pick that up. What they're doing here is saying they need this for their trial or for their appeal, when in fact they just want it in their room for their own personal gratification. There is an exception for use if a judge orders for use in an appeal process in court. They can't get those documents, but frankly, the GBI and the Department of Corrections would like for them not to have this just for their own personal gratification.
How does the warden know who that's a picture of? Unless they've autographed it or they got their name on it or something. If it's just a picture of a person, how do they know who that is?
Well, the warden has a record of the crime and all the documents related to that, and I think it's pretty evident that you got a picture of a crime scene, what it is, and that's not appropriate for a prison cell. The prisoners wouldn't have this if they didn't file open records requests to get it, and that's what we're trying to prohibit.
Well, I guess what I'm trying to get at is if I have a photograph of a person in my cell, I guess that's not prohibited just because it's a photograph of some person.
No, the warden has the right to take away any sort of contraband in the cell. Well, they're saying this is not contraband because it's being used to defend myself.
Sure.
So, are they saying that the warden knows or should know all the iterations of that victim?
Well,
that was a child victim 10 years later, he's still in prison. He's now got a picture of somebody that's 10 years older. Does he know that's who that is?
Well, they know what has been requested in terms of crime scene photos, and up to this point, those crime scene photos were able to be obtained by the inmate. What we're saying is those crime scene photos do not need to be afforded the inmate for their own gratification, but it does allow those photos to be used in criminal defense.
Well, I guess what I'm asking then is, I'm not sure this really gets to that issue, because I think what I hear you saying is that what you're trying to prohibit is photographs of the victim that the inmate has obtained through discovery, ostensibly as part of his defense, his own defense.
Exactly.
Okay. Now, even if that's the case, he's not allowed to have that in the cell. Doesn't he?
Yes, he is. Yes, he is. That's what the warden is asking me to stop.
But how can you stop him from having pictures of the victim that are trying to defend himself in the trial? He's acting
Because
if I'm the attorney, I got right there.
that's the purpose of the bill.
But my question is, I'm not arguing, I'm just not sure I understand what you're saying. If I'm the attorney, I can get everything that's discoverable and everything that could be used as evidence in the trial.
We're not opposing the attorney having this.
But if I'm acting as my own attorney, if I'm an inmate, which inmates often do, they're jailhouse lawyers, and if they decide to ask for that information by the process of discovery, representing themselves, you can't prohibit that, can you?
This is section E on the second page. If you need to borrow your glasses.
Maybe just read it to me.
This code section shall not apply where the photograph or picture is needed for use in any civil or criminal proceedings, provided that the inmate receives permission by the court having jurisdiction over the proceeding, and only for so long and in such manner as is directed by the court.
Sure.
See, I have a problem with that, because if you're acting as your own attorney, the court can't make me give that information back. I'm entitled to it under the Constitution of the United States and the state of Georgia, if I'm acting as my attorney or if I'm representing somebody. I can keep that as long as I want to, and they can't make me give it back to me.
Well, Representative, that would be your prerogative to not support the bill in that regard, but we're trying to solve a problem where inmates that have abused, have murdered, have molested, have raped people.
I'm with you on that, believe me. But my point is that I'm not sure that's what this is doing. See, when I read the bill originally, when we first started, I thought what we were trying to do is keep just a photograph that he might obtain of the victim from some other source other than through discovery or as part of the process of defending himself. I thought that's what the issue was. What I'm understanding now from this is that we don't want him to be able to keep the photographs of the person that are part of a evidence file in the trial of the case. And I'm just not sure you can do that. Well,
I guess that would be for the courts to decide should this bill pass. The warden can already take any photographs that the victim might have, or any contraband that the victim might have, that the perpetrator or the inmate might have. What we're trying to stop, and the court can direct that even an inmate defending himself could have these photos for his defense, but it's only as it's directed and in such manner as the court defines that. So, a judge could say for a given amount of time, under these circumstances, you can review these materials. But I guess it's just a case that may have to wind up in court to determine it. But for the sake of all those wardens out there who are trying to keep order, I think it's an important bill.
Further questions? Further questions? Representative Levitas is recognized.
I have a motion to amend the bill, and this would be beginning on page 1 at line 19, beginning with the word where, striking through to the end of the sentence, but not including the period. So that the paragraph, or I guess it's subsection B, would read, an inmate who is serving a sentence for a violation of Chapter 5 of Title 16 relating to crimes against the person shall be prohibited from possessing or carrying about his or her person or maintaining in any prison cell or similar area under his or her control any photograph, picture, or similar depiction of any victim of the offense for which he or she is serving, period. And at appropriate time, I'd like to explain my motion to amend.
Is it your intent to strengthen the bill?
It's, in my view, it's in my intention to strengthen the bill.
Do you understand the amendment?
I understand. We still have the exception on the second clause on the second page, I think, which we have to have constitutionally, but I would accept the amendment.
You would? Okay. Well, is there a second to the amendment?
Second.
All right. And the author accepts the amendment. Is that accurate, Mr. Leader?
Yes.
Is there any objection to the amendment? I'm sorry? Got an objection. All in favor, any further discussion on the Levitas amendment?
I'm not real clear on that. Can you
Okay.
repeat the
Representative Levitas, would you like to restate the amendment?
The amendment would strike, beginning on line 19 on page 1, would strike, beginning with the word where, up to the period at the end of the sentence on line 20.
Putting a period after the word serving.
Correct.
Are you with us, Representative Mangan? Okay. Is there any further discussion on the Levitas amendment? Any further discussion? Hearing none, all in favor of the Levitas amendment, please raise your right hand. Dan, you're going to stand up if some of these, some of our members can't raise their hands. They all count the same, ladies and gentlemen, whether they're this or this. All opposed? The Levitas amendment has been adopted. Further discussion on the bill? Any further discussion? What's the pleasure of the committee?
Have a motion.
Representative Levitas?
As amended. By substitute as amended. I'm sorry. Move to pass SB 34 substitute LC 350537S as amended.
Is there a second?
Second.
We have a motion. Senate Bill 34 be given a due pass recommendation by committee sub as amended. Is there discussion on the motion? Is there discussion? All in favor of the motion, please indicate by raising your right hand. Okay, all opposed? The bill has been passed. Thank you, Mr. Leader. Okay. That gets us down to two bills. Chair is going to call Senate Bill 276.
This is the current substitute.
Okay.
It has the worked out language between the two.
Does Senator Staten, Senator, if you want to come around, and has he seen this?
I'll give him one.
Okay. 276. We have one bill remaining after this one on today's agenda. That changes. It was added. Could you not feel the love? Senator Staten, Daniel is passing around what I understand we're going to be operating from today, which is a committee sub to Senate Bill 276, which is LC 283720S, and you have that. And
yes.
While he's finishing up, it's my understanding that this is the product and I don't want to say of a consensus or an agreement, but this is the product of some very extensive discussions involving lots of parties over the last several days regarding some concerns and issues in the bill, and that this represents your efforts at trying to resolve to the fullest extent possible those concerns. Is that accurate?
That is correct, Mr. Chairman.
Okay.
Thank you very much.
Christie, I forgot. Who's carrying Senator Williams 34? Do you know? Would you mind go ahead? Representative Levitas is going to carry the Senate Majority Leader's bill. You got your own amendment ready to add to it, right?
I do.
All right. It's getting a little tired up here.
I understand.
Senator Staten, we're glad to have you with us.
Thank you.
Take us through this. This bill came through Representative Mumford's subcommittee, I think earlier this week or late last week. Is that correct?
Right. And I appreciate very much the work of the subcommittee in bringing us this committee sub today, and I'm happy to say that I'm very pleased with the work that they've done, the recommendations that they have before us. Mr. Chairman, if I could just very briefly speak, as briefly as I can, to the substance of the bill and the reason that I have brought this bill forward. I believe it's a very important bill for Georgians. This bill, if passed, will allow insurance consumers, specifically automobile insurance consumers in our state, to do something the insurance industry calls stacking of insurance coverages. Specifically, this bill will allow consumers who are injured in an automobile accident to stack their uninsured motorist coverage on top of the liability coverage of the other driver who caused the wreck. Let me give an example, because this gets very complicated very quickly, at least it does for my brain. But I think an example which is probably the best way to explain how current law works in Georgia and how it would work if we were to pass Senate Bill 276. In fact, we would be doing what I believe more than 20 other states have now done across our country, including our neighboring states. Let's say a wreck occurs, and the innocent injured person in the wreck has $100,000 in damages, health care costs, medical bills, lost wages, whatever that may be. The wrongdoer who caused the wreck has $50,000 in liability coverage. The injured person has $50,000 in uninsured motorist coverage that he has paid for or she has paid for. I believe, Mr. Chairman and members of the committee, if we asked today 100 people, if we surveyed 100 people around this Capitol, 95 of them would tell you that this injured person would be able to collect the $50,000 from the wrongdoer's insurance company, as well as the $50,000 of his own uninsured motorist coverage from his insurance carrier, for a total of $100,000 to meet the expenses that I have suggested in this hypothetical illustration. But that's wrong. Under current Georgia law, the only amount this person would get or would be able to collect is the $50,000 from the wrongdoer's insurance company. This injured person would not get any of the uninsured motorist coverage that he or she paid for. That's because under current Georgia law, unlike our neighboring states, for the most part, you only get uninsured motorist benefits to the extent that your uninsured motorist coverage exceeds the wrongdoer's liability coverage. Senate Bill 276 would change this and correct this, and I believe be good for our drivers and those who have automobile insurance in the state of Georgia. It would allow the injured person to collect the full amount of the underinsured motorist coverage that the driver paid for. In my example, the driver would be able to collect all of the wrongdoer's coverage first, and if it was not enough to cover his or her losses, then the driver could recover all of the uninsured motorist coverage on top of the wrongdoer's insurance. I would suggest to you that that is what most people probably assume that they are getting when they buy uninsured motorist coverage. And I would further suggest to you it is what we ought to provide under the law in Georgia. Under current law, the innocent person hurt in the wreck I referred to before would not get fully compensated for the harm caused to this individual. The entity that ultimately had to pay for the insured's medical bills, their health insurance company, or Medicaid, or Peach Care, would not be able to get reimbursed. The bottom line is this: the innocent injured person would get no benefit of the $50,000 in uninsured motorist coverage that he had paid for, even though the insurance company had received the benefit of the premiums that had been paid to it. If we pass this bill, however, and if stacking becomes allowed, the consumer injured in this hypothetical wreck would get the full benefit of the $50,000 in uninsured coverage that they paid for. The injured party in this scenario would be fully compensated for the harm done to them by another, and there would be the possibility for the insured person's medical treatment to be reimbursed and treatment that they receive be paid for a health insurance company for Medicaid or Peach Care. I think this is an important issue. Now, there has been a great deal in the media, a lot of conversation about how much this will cost and how much this will raise rates for automobile insurance in the state of Georgia. Well, first of all, let me say uninsured motorist coverage is not mandatory in the state of Georgia, and this does not change that. It is optional. So if there is a premium increase as a result of this change in the law, it will be up to the consumers to decide if they want to purchase uninsured motorist coverage. But I think we at least owe them the decency, as in South Carolina, as in Florida, as in Alabama, and as in more than 20 states, I believe 23 states in this country, of allowing them to get what they pay for, to get all that they pay for. We've done research on this. Fortunately, uninsured motorist coverage is one of the least expensive components of automobile coverage. We collected some data which suggests that for an average policy, the increase that was given to us, the data from one insurer, said a maximum it could be perhaps $3.50 more per month as a result of this stacking bill. And even so, when we compared the rates in Georgia that they were projecting, they were still lower than South Carolina or Alabama. I think this is an important point and an important bill for insurance of automobile consumers of automobile insurance. And I would certainly thank once again the members of the subcommittee, the various parties who have an interest in this bill, who've worked very diligently together and with the subcommittee in order to come up with this substitute. And I would certainly urge your passage. Thank you, Mr. Chairman.
Senator Staten, it may or may not be helpful to sort of kind of cut to the chase on some of these things. I know we have several people signed up, and we'll hear from all of them that still wish to speak. But when this bill, as I understand, there were about 3 issues with this bill as it came over from the Senate. We have the stacking component, which is sort of the crux of the bill. We have some issue, as I understand, with the effective date, and we'll talk about that later. But there was an amendment, as I understand, that was added in the Senate that would have substantially altered the law as it related to the duty of an insured to cooperate with their carrier, as I recall.
Yes.
And the discussions that we've had before have eliminated that from the proposed sub, or from the sub. In addition to that, I think the members of the committee need to understand that you have agreed to accommodate some language that Representative Rich Golick wanted added, and so that is in the sub also.
That is correct.
So that leaves us, I don't want to short circuit any debate, but that kind of leaves us then with the crux, the stacking component, and then some issue to do with the effective date. Is that fairly accurate?
I think that is correct in my understanding, Mr. Chairman, that the other issues you have mentioned were worked out, and I'm certainly comfortable, particularly with Representative Golick's language being in this bill. So in my understanding, we have about come down to the issue of the effective date, but it may be that there are others who would like to speak to that who will be more able to get into the intricacies of that debate than I can. I would say I think the compromise that has been reached here is a good one. It is, I believe, January of 2008, which thus means that we do have at least a fair amount of lead time in order for these changes to be processed through.
Well, to be fair, I'm not sure the word compromise is.
I'll allow others.
It's totally accurate.
In my mind, I'm comfortable with it.
But I think it's safe to say that you have certainly been over backward, I think, to accommodate some of the concerns, and I know that there are a few concerns remaining, and we'll talk about those. Questions from the committee for the author before we go to those who have signed up to speak. Questions? I'm sorry?
May I save my questions for after?
Oh, yeah, sure. Yeah. Chairman Franklin?
Thank you, Mr. Chairman. If I understood correctly, are you saying that current Georgia law allows an insurance company to not pay a claim for which premiums have been paid to them?
Well, in the example that I gave, Mr. Chairman, I think it is hypothetically possible for someone to be in a situation where they have uninsured motorist coverage, but they're not able to make a claim on that coverage, yes.
But that's in the current law?
Yes.
That basically says, as a consumer in Georgia, you get to pay premiums, but by law, we're going to prohibit you from...
Well, it has to do with the fact that under current law, you only get uninsured motorist benefits to the extent that your uninsured motorist coverage exceeds the liability coverage of the person that has caused you harm. Now, I'm sure someone might argue that all of that has been factored into a rate structure of some kind. But nevertheless, an individual going into the office or online or however buying their insurance coverage, I do not think an adequate job is being done to explain that to insurance consumers. And as I mentioned earlier, just my informal surveys of talking to people, including some insurance agents and including some people in the industry, the assumption would be, into the scenario I mentioned earlier, that both of those would apply, and in fact they do not under current Georgia law.
Further questions from the author before we start with witnesses? Representative Mangum.
Yes, sir.
This is one I'm sure that will come out within some of the other witnesses, but I will probably have to leave in a few minutes. The other states that are nearby, what are their experiences as far as
what is he drinking?
Their rates compared to Georgia rates? For example, what you can name the nearby states that you're comparing. What are their rate structures with the similar and without? Address that real briefly, please.
Yes, let me see if I have that with me. I hope I do. Here's an example, just very quickly. Under one scenario that we, in the data that we received from a automobile insurance company, the same coverage in Georgia would be $28.10. In Alabama, it would be $28.75. So that's just one minor example. In South Carolina, let's see, the difference was between $36 and $34.50. So there's not a great deal of difference, but I don't. It appeared to me that Georgia, for whatever reason, was actually slightly more favorable in some cases as it relates to the other states. Maybe it's because of our population being greater. I don't know the answer to that. I don't know how actuaries actually figure these things.
But I don't think, contrary to some headlines I've seen in some newspapers across the state, that this is a sky is falling kind of thing that we're contemplating here. And again, keeping in mind that it's optional coverage to begin with, and it is essentially the least expensive component of when you're putting together your package of automobile insurance coverage. It's not to minimize any increase for anyone. I want to be sensitive to that, but I don't think we're talking about a situation where the sky is falling or we're going to be at a tremendous disadvantage to our neighbors who may already be doing something very similar to what I'm proposing.
Thank you.
Further questions from the author? All right, Senator Staten, thank you very much. Stay with us. We're going to, we have, I think, a few people who had signed up. Lance Cooper.
Mr. Chairman, Mr. Cooper had to leave.
Okay.
I will be testifying.
Robin Clark.
And I would defer to Commissioner Oxendine at this time.
Okay, is the commissioner here? Well, Commissioner, I can't see back there in the darkened corner. Come around, please.
Chair, I just snuck in here back.
We're glad to have you with us.
Thank you.
We're honored to have you with us, I should say, too.
It's my pleasure to be here. This is a bill that has gotten a lot of attention, and I think it's something that's very important. You know, it's a lot of talk, and it's a lot of people here. You said want us to speak about it. I've heard what the trial lawyers want. I've heard what the insurance companies want. I really don't know. I haven't talked to the companies. I haven't talked to the trial lawyers. I haven't really talked to anybody about what the various industry groups want or don't want, whatever, and they may have various arguments. My concern is, of all the people in this room, of all the people in this state, there's only one person that is charged with the constitutional duty of looking at all of the facts and determining what our citizens are going to have to pay for automobile insurance. And that burden falls on my shoulders. And it's a very heavy burden. It's a burden I take very seriously. We are very strict about the rate filings and how we review those. That's why of the 10 largest states, Georgia's the 9th largest of the top 10 states, the states that have major metropolitan areas like Atlanta. We're one of the lowest states. We switched back with Illinois. I think they're currently a little lower than us. But we're lower than most big states when it comes to automobile rates, and we work very hard for that. There's a big confusion about what is this coverage, and because I've heard different stories, and I want to kind of address that real quick. Coverage, whether it's underinsured or uninsured, it's really the same thing. And it's simply a matter of what consumers are supposed to be doing is they sit down with their agent, and the agent should say, if you get hit with someone that has little or no insurance, what do you think you need to take care of yourself, to fix your car, to take care of medical bills? What do you think you need to have as an umbrella protecting you? And you pick it, 100,000, 200,000, 300,000, whatever that is. And the company prices that degree of coverage. The insurance company is not ever saying, if you pick 200,000, I'm going to give you $200,000. That's not what the policy says, and that's not what they're pricing it on. They're saying if you have 200,000 in damage, you got to have the injuries first, and that person has less than 200,000, we will make up the difference. Actuarially, that making up the difference is a big difference than saying we're going to give you 200,000. It's a major difference in those two. If people think they need more money, they can get 300,000 or 400,000. I have no problem with that. If someone wants to have a stacking system, I have no problem with that being done as a choice. The concern is what this bill would do is say to your constituents and to mine that you have to make a choice right now, today, when you're buying your insurance. Either you go naked with no UM coverage, And I personally think that is a very dangerous thing to do. Or you buy the coverage and you're going to be buying this enhanced product that this bill provides for, and you're going to pay the greater price for it. Now, it's a lot of people talking about, well, it's not going to cost much. I can tell you, there's only a handful of people in this state that know exactly what how something's going to affect. And those are the people working in the Georgia Insurance Department. Those are the best experts available to you as members of the House of Representatives. And on their best estimates, and these are estimates, that if someone has total comprehensive coverage, they're going to see approximately about 9.7% increase. That's about a 10% increase. If someone has liability and UM and they don't have the property coverage because their car might be a little older and it's paid for, they're probably going to have about a 21.3% increase. The cost to Georgia consumers is going to be about $400 million per year, each and every year. And that's a lot of money. And I don't think that it's appropriate to put that burden on the citizens without seriously weighing all the options. There's a lot of other solutions that can be done. Some type of option on how to do stacking. Another solution, very simply, if, Senator Staten just said that he thinks consumers are confused. We haven't received complaints of citizens being confused. He's a very honorable and honest man, and if he says he thinks people are being confused, I'm sure he thinks that. If they are, I'm the number one person that wants to stop it. If there is any Georgia consumer that doesn't know what they're buying, I want to rectify that right away. There's a lot of things that we could do to rectify that. Talked to my staff earlier today, and they said if we had the statutory authority to do a uniform standard form in the state of Georgia that would be a disclosure, that would explain all the options and give consumers the tools so they know exactly what they're buying and can make a more informed decision. That we could mandate one standard universal form that every company would use, everybody would have to sign, black and white, written on a third grade education or whatever we need to write it on, and we can do that. I do need that statutory authority, but we had that, I would do that in a heartbeat. And those are solutions that can be done. There's a lot of things that I think we could probably sit down over the summer and work out solutions to this. But if we work it out over the summer, we can come up with a solution that's not going to put this huge burden on the policyholders. If we go with this bill, we are putting a major burden on the consumers of Georgia and sticking them with this bill. And I think it's something that should be weighed very carefully. One or two real quick last figures is if you have an individual, currently the coverage could go from $60.60 to $91.90. That would be a new UL premium of $151.60 for a family of a mother, father, and two youthful drivers. We probably got a few people in this room, probably a few people in the legislature who got youthful drivers. Mom and dad and two teenage drivers. You would go from about $240 to $606. That's what would probably happen to some of your colleagues in the General Assembly. That's what would happen to countless numbers of your constituents. I would love to address any questions that anybody has, but I strongly encourage the committee, don't rush into this. If there's a problem, let's fix it. But, there's been a lot of talk in the paper about this session, and people said, gee, the legislature isn't passing a whole lot of bills. And most of the comments I've seen from members of the General Assembly on the House and Senate both have been, we don't have to pass a lot of bills. We're supposed to pass a budget, and everything else, we look at it, we reflect it, and we only pass the bills that are really good for the people of Georgia. And whoever said the legislature has to pass 1 million bills every session? Well, maybe this is one of these that doesn't need to be rushed through, and we need to come up with the adequate solution that's best for everybody. And I'm happy to work with anybody on this. to do what's right for the people. Thank you, Mr. Chair.
Thank you, Commissioner. I share your concern about rushing things because I don't like to do that either. And I think that we have tried to, at least on the House side, do things on this bill in a very deliberative way. And frankly, I came to a conclusion that we could wait probably 5 years and not have an agreement on some of the core issues involved in this bill. I appreciate your comments, but we certainly haven't rushed things along. Let me ask you a question about rates, and I don't understand how the mechanics of that, so this is sort of a technical question, I guess. Historically, are rates for coverage, have they been based on the fact that in the scenario that Senator Staten gave earlier, if I have 25,000 liability and he's got 50 and if I run over him tonight when we leave the building here, which I'm tempted to do after he brought this bill to me, are you suggesting to us that rates have historically been just explicitly based on the fact that he's only going to get $25,000 of his $50,000 paid for coverage?
Yes. The actuarial assumptions when the rates are being done is that the coverage will be offset by whatever the wrongdoer has, whatever coverage they have. And that's the actuarial assumption. That's why this would be such a big rate increase. If it wasn't for that, it'd be no big deal. That's what makes it a big deal. And that's why I think there's so many ways we could work this. The current solution is pretty easy. If you want to offset that some guy may have $50,000 coverage that I don't get, instead of $200,000, you buy $250,000 of coverage, and that would take care of that situation. But we could work out so many solutions on this.
And let me ask one more question, and I know some of my members have questions for you, and we greatly appreciate your being here.
Thank you for having me, sir.
So one of the things that I've been very, very sensitive to is the role of independent insurance agents that deal with people out in the fields, or maybe they're agents for some of the carriers that are friends of mine. So are you suggesting that, and I know they've been concerned about, the obligation, I guess, this puts on them in terms of advising insurance customers of their coverage, that they should be advising people now, if we don't change the law, that if you want $50,000 of then you probably need to buy $100,000.
A good agent should be doing that.
Okay.
And I would hope a good agent a good agent would be doing that and adequately explaining it. We checked our database and we could not find any complaints where people were calling saying we didn't understand what was happening. Mm-hmm. Now, everyone who has a problem doesn't pick up the phone and call a state agency and ask for help. Sure. I wish they did. They don't. So I'm sure there are people confused. And that's why we could have a disclosure form, one little piece of paper that, you'd have to be dumb as a rock not to understand. I mean, just written on a elementary school level that anybody could understand and really explain it to them. That could easily be done. If I had the statutory authority, that would be a binding document that companies would be required to use. It would be accepted in court as appropriate disclosure, and we could do that in a heartbeat. And this body, along with the Senate, could give us that authorization and give me that mandate to create that document.
And that really could address not only but liability and med pay or whatever else.
So many issues.
Yeah. Okay.
Any issue you tell me you want it to.
Okay. We maybe should have that discussion. I like that idea. Chairman Franklin?
Thank you, Mr. Chairman. Going back to Senator Staten's hypothetical of let's say you run me over on the way out of here. You've got I sustain $100,000 worth of damage. You have $50,000 worth of liability.
I do have a little bit more than that, but go ahead.
Okay. Well, I'm glad to know that since I know I'm in your sights. But in this hypothetical, then I've got $50,000 of underinsured coverage, and so your liability coverage pays the $50,000. What happens to the $50,000 of underinsured that I pay premiums for in this hypothetical?
Yeah, because I heard your question earlier. The assumption you're making is that if I buy $100,000 of UM coverage, I'm paying premium for $100,000. You're not. You're paying premium that you will have $100,000 of coverage either from your insurance company or someone else's. And statistically, the actuaries know that statistically how many other people are going to have zero insurance, how many are going to have some, statistically how much it'll be, and they make and insurance is an educated guess. That's what actuarial science is, and they base it on that they're not going to be giving you $100,000 every time. Odds are they're going to be paying less than that because they're going to collect the money from the wrongdoer.
Does that not concern you that the premium payers of the state of Georgia are paying premiums for something that the insurance companies know they're not going to pay a penny on?
No, they're not paid. That's entirely incorrect. They're paying not for $100,000 of money from the insurance company. They're paying premium for a guarantee of coverage. And the insurance company is guaranteeing that we will make sure some way or another you have $100,000 of coverage, either from the other person or from us. If they knew it had to come from them every time, they would charge a little more. Another example would be life insurance. Life insurance rates actually take into the calculation of the rates that a certain percent of people are going to buy life insurance and drop it. It's called lapsing. And they're just going to let it lapse, and they're going to decide they don't need it, and long before they die, they're just going to give up their insurance and forfeit money that they've paid. I mean, that's a choice that sometimes people make, and they actually take that into the calculations. I mean, all these actuarially work together. And it's not that you're paying for $100,000 money from your company. We can do it that way, and this bill would do it that way, and it can easily be done that way. The problem is you haven't been paying that way in the past. To start getting that privilege, you will have to pay more, and that's where you'd probably end up with close to a 10% increase.
Changing that hypothetical a little bit, let's say you only had $25,000 in liability. I've got $50,000 in underinsured coverage.
Okay.
And you've damaged me to the tune of $100,000. So your $25,000 kicks in. I've got $50,000 of underinsured. How much from my insurance company that I paid premium for do I get?
Well, you bought $50,000 of coverage, so the total coverage from both sources would be $50,000. If you remember back when I first...
But in this one, does that mean that my policy is only going to pay $25,000?
Yes, you'd be short.
So though I'm still underinsured.
You'd be short, yeah.
To the tune of an additional $50,000, but I only had $50,000 in coverage. You had $25,000, my $50,000. That leaves me $25,000 short in the total damage to me. But you're saying I'm only going to get $25,000 out of mine that I pay premiums for $50,000 for.
Well, you pay for coverage of $50,000, and you will get $50,000 in coverage. Some of it will be from your company, some of it will be from the other company. Let me go back to what I said in the very beginning. What should be happening is when you buy insurance, you should sit down with your agent, or your agent should sit down with you and explain it to you and say, if you get hit by someone with little or no insurance, how much money do you think you need to take care of medical bills, getting your car fixed, other damages, whatever? What do you think you need to feel safe? And in that chance, if you said, I think $50,000 would cover it, and your medical bills are $75,000, you miscalculated, and you chose 50. Maybe you were trying to be overly frugal or something, and you chose 50 in your bills. You miscalculated. You made that mistake, and you don't have enough coverage. That's why I have a lot of coverage, because I want to make sure I got plenty of coverage. And that's why I don't personally have 50,000. I got a lot more than that because I want to make sure I'm okay, because I'm planning ahead. It's personal responsibility of saying, what do I need to make myself whole, and come up with that figure and tell the agent to put that down. That's exactly what we're talking about.
Again, Commissioner, thank you so much for being here. I know you've got a very busy schedule, so I know that we all appreciate your being here. I want to start with the $240 to $606 figure that you mentioned. Is that based on a study of the 23 other states that Senator Staten mentioned?
Those figures, when you're looking at other states have different laws, different coverage area. You can't compare a different state to Georgia because the coverages are different, the laws are different. There's so many different factors. Different states have different level of tort reform, various other things, complete differences. You're comparing apples and oranges in that situation. What we did was we went and took the largest carriers in the state of Georgia, and we used data from the largest carriers representing the bulk of the market. And we looked at their figures. We looked at their actuarial data. And we looked at what actuarial assumptions, legitimate assumptions were being made, what assumptions we would have to make if there was this change. And then we computed these figures. I mean, did I look at every single automobile company in Georgia? Of course not. That would be like 1,000 probably companies writing personal auto, and it'd take an army of people a long time to do it. But we basically looked at a handful of companies that represent almost half the market.
Right, and I mean, what little I know of statistics, and I know very, very little, not even enough to be dangerous, you wouldn't, of course, have to go poll every insurance company to come up with a statistically significant sampling, so I'm not suggesting that you do that. I guess what I am wondering is if they're not among those 23 states. Well, first of all, I'd be interested in the abstract whether, regardless of what their schemes are, if once they move to a scheme like the one being proposed by this legislation, if based on their own scheme there was a shift, essentially close to a 2.5 or 3 times.
If they changed, was there a big increase?
Right, because this is about 2.5 times. From what I'm looking at, the numbers.
On the family, it is.
On the family, yeah. So that would be one question, and then a related question to that would be: if among the 23 states, is there not one that, even if of course, their laws aren't going to be identical, but they're not comparable enough to make a comparison?
We can definitely gather that information from the other states. The problem is the issue of time. Can we do it before y'all go home on Friday? And that's the problem,
right,
is that we can't. That is something that we could work with this committee, we could work with the senator over the summer, and definitely come up with all those figures. And there's a million different ways you could do it. I mean, Florida you can buy it with stacking or without stacking. You can do different things. Some states it's all stacking, some states it's not stacking. There's a million different scenarios, and I like more choice. The more choices available to Georgia consumers, the better. Let them pick and choose from everything in the world, and I'm tickled pink.
What is the gist of what's being proposed in this policy? Is that something that, under your existing authority, you could do without legislation? Could an insurance regulation require the same things that are the subject of Senator Staten's proposal?
We're talking about this aspect of it. I think
right.
there's some other issues
stacking.
On the stacking issue. We could could probably go in and require the companies to file the UM as part of their actual policy form. We approve their policy form. There would probably be a backdoor way of doing it because we could make them file it as part of their policy form, which they generally don't do. We would basically hold up their policy form. We could find out. There's probably a way to do it.
Okay.
Yeah, they're getting nervous back there.
I understand.
But yeah, there's probably a way that we could make it work.
Okay, and I just want to touch on a couple other points, and I really appreciate, Mr. Chairman, you giving me the time to ask these questions, but I find this not only interesting, but I understand the competing interests that are here. I will tell you that I believe that we all share at the heart the consumer's best interest. That's what we're trying to get to, at least I hope. But I guess one of the two issues that really concerned me when I heard you speak were the issues of what I consider to be burden shifting. And I never liked legislation that or policies that have burden shifting in them. And I ask this genuinely so that you or the subsequent speakers can address this, but I'm wondering if there isn't a sense that we are shifting the burden to the innocent injured in an uninsured or uninsured motorist case by saying that though your policy appears to be $100,000, it actually isn't under various circumstances. And if you want more, if you want to be protected, then you have to come out of your own pocket more because we're going to deduct from the person that injured you. We're going to count that as part of your policy. In other words, all of a sudden I have, in my judgment, not received the full value. And I do understand completely what you're saying about how the policies are figured and calculated, and I understand that. I guess one of the places I'm having my trouble getting my arms around in a substantial way is whether or not the consumer really understands that. And I will be quite candid with you. I don't find a lot of credence in an argument that says if this was a problem, a lot of folks would be running and calling your office, and that's no disrespect to you at all. It's just that I really question, and this is no disrespect, there's agents out here and brokers for whom I have the utmost respect, and I would not put these into the category of most folks. But I truly wonder whether when someone's buying that kind of policy, whether they understand the limitations you're talking about. And I understand what you're saying, that we could come up with a one-page document. I guess one question would be why that's not there now, why we don't have that existing, is one. And then the other question would address Representative Franklin's scenario. And your explanation to him reminded me of rebates. Rebate forms are designed as part of the cost of an item when they offer a rebate that some folks won't remember to send their rebate forms back in. That's how they price, and we had folks from the industry come tell me in another committee that I'm on exactly that. We calculate that. We intend folks to not send in the rebates, and if they actually send in their rebates, then we'd really have to up the price of the product. So I'm a little bit concerned that we may be venturing into that kind of territory. That's a long question, and I'm famous for them on this committee, so I apologize. But if you could address that as best you can, I'd appreciate it.
You may have to help me if I miss some of the question. You may have to come back and remind me and point out to me. The main question basically sounded like, or a major question was, why don't we have that form right now? And I'm hearing reports that there are attorneys around, probably one or two attorneys in this room, I guess, that there are attorneys around the state saying, gee, this is a problem. People are always walking into my law office saying it's a problem. I haven't heard that until very, very recently. If that's a problem, I'm the quickest guy to want to do something to stop that. If I talked to my staff about what we could do on requiring a form right now, we could require a form that these insurance company people out here have to sign or give to the consumer to sign. The problem you're going to be running into, and UL is apparently a highly litigated area, that without a statutory mandate, if we did a form, the insurance company's bound by it because they have a license from me. They have to do what I tell them to. But it's not going to be presumed in the courts as being an acceptable disclosure, an acceptable form. and you could run into a major litigation issue of, well, this is the form you used, and yeah, I don't care if the insurance commissioner told you to use that one, but it's not acceptable, and I'm going to go get a judge or a jury to say you should have used a different form or a better form, and that could really cause a lot of litigation confusion. The legislature could mandate a particular form, and then it's done by the legislature. I would tend to think, because sometimes you need to massage things, it would be more appropriate if the legislature were to authorize me to do that official form. Therefore, if it needed to be tweaked, it could without a full act of the General Assembly some later time. But I had that very discussion. And why hasn't it been done in the past? I mean, I really hadn't heard these complaints. I think the burden is going to be shifting a burden to the people who traditionally have been properly calculating. The person that said, you know, I could run up $250,000 in medical bills. Well, I can't trust that someone else is going to have insurance, so I want my insurance company to cover me for up to $250,000, and that's what I'm going to buy, is $250,000 coverage. That prudent person has been doing what they're doing. Well, that person is going to be punished by someone who, Representative Franklin would never do this, but bought less. In your situation of where you bought 50, but maybe you should have bought 75 or 100,000, and it's subsidizing that person who actually bought less instead of punishing the person who was, exercising personal responsibility and buying the appropriate amount. And keep in mind, this is going to be a black or white thing. I mean, either you go with no coverage, which is very dangerous, or you buy this more expensive coverage and pay the extra price. And I think that's a difficult situation to put a lot of people in. I don't know if I addressed all of your questions or not. There was a few of them there.
The last one was the rebate, but if I ask it again, I think the chairman may shift me to another committee. So I appreciate your time and the information.
He's about to go make that request right now.
All right. Are there any other questions, Insurance Commissioner?
Here, I've got to go down to Senate Judiciary Commissioner, and I hate to run off on you, but Vice Chairman Mumford's going to chair for a little bit till I get back.
Mr. Chair, before you leave, once I finish with questions, do you prefer me to hang around, or do you? I don't. I'll be happy to stay if you need me to. There are some other issues I need to attend to, but I can stay if you need me.
I don't think that's necessary. I mean, I'm sure Mr. Krim will be here.
Yes, Mr. Krim will be here.
Okay.
Okay.
Thank you.
Ms. Abrams.
Thank you. I will tell you, you have a very able deputy who spent some time talking to me about this, but I wanted to clarify a few things that you've talked about. First, can you talk about the number or percentage of policies that in the state of Georgia are actually sold over the phone or via the internet without actually sitting down with an agent?
I mean, we could probably get that information. I don't have that off the top of my head.
Just speculating. Would you say it's roughly half, a third?
No.
A third?
I mean, it's a minority. Most people like the face-to-face agent thing, whether it's an exclusive agent of like a State Farm, Allstate kind of person, or an independent agent that represents several companies. That's clearly the choice. The Geico model, the USAA model, as two of the larger companies that are more telephone, internet-based, is definitely a minority, and it is a good product and good model, but not what the average Georgia consumer wants. I just, off the top of my head, it would be hard to throw out figures on that.
Well, I would like to...
I would tell you that about 85% of Georgia citizens do buy coverage.
Okay. And then I would like to I'm going to give you some numbers that are responding to percentages that you put out because I want to make sure that I'm framing them properly. But assuming an average policy cost of... would $970 a year be... where would that fall in the range of policy costs? Because part of my concern is if you say 10% or 21%, it sounds like a fairly high number, but in terms of actual dollars, if you've got a policy of $970, a 9.7% increase is $7.84. A 21% increase is $17. Even using your example of the shift from $240 to $600, that's about that's about $25 a month. So my concern is that when you use rather graphic percentages, that gives the false impression of a high dollar value that's going to be ascribed to the consumer, and I want to know if my numbers are reflective of the actual status.
Well, I would submit to you there's a lot of folks that say, $10, $25, $30 is a lot of money, and they don't want any increase. And keep in mind also that we're talking about increases merely because of this bill. I mean, the price of milk and eggs goes up, the price of everything goes up, the price of insurance is going to go up from time to time anyway. So it would be this increase plus any other just routine increase that would exist in the normal course of business, which we know everything goes up from time to time. Saying what different people are going to have on a policy price varies so much. We gave estimates of what if someone is paying $900 a year, and that could be someone that is a very good driver. But you start adding kids on it, you're paying a lot more than $900 a year. It depends. Do you have a Mercedes or do you have a Chevrolet? I mean, there's so many different factors. Do you live in Atlanta or do you live in rural Georgia? There's so many different factors as to what the individual impact on people are going to be. What we're talking about are general averages. What I can tell you as a figure is literally $400 million is the estimated additional cost.
But that's
going to be paid. $400 million per year, each and every year, that Georgia citizens would pay under this bill.
But amortized over how many drivers? I guess my concern is that while I understand the drama of the numbers, when you break those numbers down by the actual number of people, what the actual impact to a consumer is, I think that it's important that we sort of frame this properly. Because my other concern is, going back to Chairman Franklin's example, the extent to which you have a consumer who considers themselves sophisticated, or at least considers themselves completing their due diligence, and they're given bad information, if not intentionally malfeasant information, by an insurance agent who suddenly is out $25,000, they have no remedy. Yeah. Their only remedy was to have assumed 5 years ago, because I will tell you, my insurance policy, I got my insurance policy 10 years ago. I am deeply anal retentive, so I do understand why what my policy says. But I haven't gone back to talk to my agent since then, except for the normative increases when I add something or change a car. But if I were to be in an accident, it strikes me that your average consumer would have no remedy other than a stacking option if they were to find themselves with a catastrophic accident that exceeded the $50,000, which is, I think, a very moderate example, as opposed to another example of having $125,000, $200,000 worth of injury, and assuming they received sufficient coverage. So I guess my concern is, and what I'd like your response to, is what the remedy is for the consumer who doesn't understand or may not have access to the very careful and considered conversation that we've gotten to have here.
I mean, in general, the remedy of any insurance consumer, whether you're talking about home, auto, life, whatever, is if you don't buy enough coverage. I mean, that's an issue that's happened in some of the other states with people not buying flood coverage, and that's why a lot of people run into some issues of not having flood coverage. Thank God we haven't had those issues in Georgia that some of the other states have. But you do have personal responsibility to decide what that appropriate level of coverage is. If someone picks a lower level of coverage and they underestimate it, that is their personal responsibility. Stacking is sort of a luck of the draw. I mean, if you get hit with a guy with no insurance, stacking doesn't help you. If you get hit with a guy that's got $1 million of insurance, you don't need stacking. You make out like a bandit. It's just a total luck of the draw. That's why you're supposed to say, I'm going to pick that figure using my personal responsibility and being responsible for my actions of what coverage I need. You do that with your house. If you insure your house for $200,000 and it's not a replacement policy, and that house takes $250,000 to rebuild because it burns down, all you're going to get is $200,000. You're not going to get the other $50,000, and you're going to come up short and not have enough money to rebuild your house. I mean, those things happen routinely. But when you talk about the consumer may not understand and there may not be adequate disclosure, I would love to try to fix that. And I think we could have that fixed. Matter of fact, especially if I was given specific statutory instructions, we could have that fixed this summer. We could have that fixed long before y'all come back, or we could work over the summer and come up with a detailed solution and bring it back to you in January for y'all to pass. But if I have that authority, we get that done this summer. I mean, we'd have that done real quick.
Mr. Chairman, can I ask one follow-up question? Can you speak to, and I don't hate doing this, but you probably won't like answering it. Can you speak to the benefit of stacking? Why 23 other states have investigated and have invested in stacking as an option for their consumers?
It's a different philosophy of how you want to do it. It's the same thing, you know. I personally think a Mercedes is better than a Chevrolet. But do you want to drive a Mercedes or do you want to drive a Chevrolet? If you want to drive a Mercedes, it's a much better car, but you got to pay more for it. The problem with the stacking is it's not going to give the choice. I would rather the citizen have the choice to do it the way they're doing it or to do stacking. If people want stacking and want to pay extra for it, let them do it. But don't make your constituents that are happy with the status quo pay more. I mean, shouldn't they have the choice? Should government really be going into people's pocketbook and literally taking money out of their pocketbook and forcing them to have this enhanced coverage if they don't want it? Give them a choice. I have amend this where they can do stacking and not stacking and let them pick and pay according to what they want to do. I'd be fine. I could care less. I would have no problem with that. I think there's some other people out here that might have a problem with that, but I have no problem. But I just don't like the government coming in and saying, this is what you have to do, and by the way, you've got to pay for it, and you don't have a choice. I don't think that's why we, you and I and all of us, were sent here as elected officials to represent our constituents, and that's my concern about it.
Thank you.
Mr. Bearden.
Very direct question that will just need a very direct answer.
I'll try to be real good.
Right now, how much money does Georgians pay a year for coverage?
You talking the average automobile?
I'm talking about total. How much money a year is being spent in Georgia by Georgian citizens for coverage?
David, can you call Greg real quick and get that number? We can get that in just a quick minute.
Okay.
I know someone who has that number off the top of their head.
I'll tell you what we might
personal.
do. In the interest of time, if y'all get the number, we may just provide that, and we'll let the committee know what that figure is. Did you have a question, Mr. Levitas?
We'll just pass you a note.
All right,
we've
got a lot of witnesses, and we're very short of time here, and I want to try and make this.
And this will be just one question. No matter what the response is, this is it. My question goes back to personal responsibility because I'm a big advocate of that. And you mentioned two things. One, requiring folks, this is what you will get and won't get. We've already do that by requiring minimum coverage on automobiles, right? Part one. Part two is, isn't it somewhat of the personal responsibility? We're talking about someone who is the victim of an automobile accident. If that is, isn't it their personal responsibility to have an adequate amount of insurance on their car in the event they injure somebody? Whether I have $50,000 or $250,000, isn't there some personal responsibility of the person that ran into me to be adequately insured?
Almost definitely. And before you joined this august body, years ago, the legislature essentially doubled the minimum liability requirements, and I was the one who lobbied for that. I'm the one, as commissioner, that went, actually it started in the House side and said, we need to increase this. It's way too low. And I wouldn't mind increasing it a little bit more. But everybody should buy insurance, and I think the statutory minimums are very minimum. They're about twice what they used to be, which is a move in the right direction.
All right. Thank you very much. Any other questions for the commission? Yes, sir. Thank you very much, Commissioner Oxendine. It's a pleasure
and we'll
to see
just
you.
Maybe stick our head in and just give you that quick number, and
that'll be fine.
Not make a long speech when we get that number. Just
all
for
right.
a few moments.
I have some other people down. I assume Mr. Krim is taken care of off my list since you've talked.
Unless you have any follow-up questions,
all right.
he will be here.
Thank you very much. Emily Bagwell, please.
Good afternoon. I'm Emily Bagwell. I represent the Georgia Association of Property and Casualty Insurance Companies here at the Capitol. GAPSIC is a trade association composed primarily of domestic P&C companies, that is, those who are headquartered here in Georgia. Our organization has significant concerns really with the underlying philosophy of Senate Bill 276, the idea of eliminating the set-off or allowing stacking, as we've referred to it today. And our concerns primarily surround the increase in premiums and the unintended consequences of more people opting out of their coverage, which is optional coverage, as Commissioner Oxendine referred to. Right now, coverage in Georgia is very affordable. It's rated a price based on the current law. But rather than me do a lot of detail on this, I've asked one of our member companies, Southern General, to send a representative here today to talk to you some about what they see the potential increases would be, so that y'all could hear from an actual representative of the industry. So I'm going to defer here to Mr. Quinn with Southern General.
Good afternoon. My name is David O'Quinn. I'm the Chief Underwriting Officer for Southern General Insurance Company, which is a domestic insurance company here in Georgia. We are a specialty company, a non-standard insurance company. 99% of the clients that we write purchase minimum limits. And as we're looking at the impact associated with this change, we're seeing the largest impact associated with those minimum limits consumers. Very similar to the figures that Commissioner Oxendine had. Right now, we're looking at an average premium for uninsured motorists on a policy of $65. And what we're anticipating as a result of this change is an average premium on the policy for uninsured motorist coverage of between $195 and $230 per 6 months. And so that amounts to an increase on a monthly basis between $22 and $27. While that might not sound like a very large amount of money, for our clientele, which is on fixed incomes and typically low wage earners, that's a very large amount of money for them. The figure was issued earlier in terms of 85% of the customers, the citizens of the state, purchasing uninsured motorist coverage. Now, on our policies, the figure is dramatically lower. And this is just to give you an example of truly what the impact is on your minimum limits consumers, those most at risk in society. Our consumers purchase 40%. 40% of our consumers purchase uninsured motorist coverage relative to the 85% figure that was tossed out previously, that was utilized previously. And we believe that the necessary premium increase as a result of the statutory change or proposed change would be one that's going to drive more people to drop the coverage, to drop it from approximately 45% of our customers purchasing the coverage to something lower. I don't know exactly what that is, but I do feel like a premium increase in that $130 to $160 range is likely to cause quite a few people, upon they receive their renewal notice, their premiums, to go, whoa, what happened here? My premium went up a lot. They have to go back to their agent, and then they have to make a decision. There was the assertion that they've got the option of purchasing. Well, yes, it's true. They technically have the option of whether or not they want to purchase the coverage. But often when it comes down to, do I buy groceries, or am I going to pay this up rate of $130 to $160? That's not truly an option. And that's.
Thank you very much. Any questions? All right, I don't see any. Thank you very much. Mr. Bobby Potter.
Thank you, Mr. Chairman, members of the committee. I am Bobby Potter, and I represent State Farm Insurance Company, which is the largest writer of auto insurance in the state. We have a bit of a different market than the gentleman, that Mr. O'Quinn, who just testified. We do have concerns about this bill. The effort from Senator Staten and from the Georgia Trial Lawyers Association is to expand coverage in these circumstances, which is understandable. our role as an insurer in the state and as an entity that's in the market to make money would be to sell more coverage. So it makes sense. We would want to do that. So the question would be, why in the world would we oppose this? More than likely, insurers would, in fact, make more money under this scenario. And the reasons that we are concerned about this have been expressed, and they are three. It will cause a cost rise across the board, and it will. Secondly, the amount of coverage that one wishes to buy is available now. It's voluntary. It's available now. If you wish to have more to cover yourself, you can do that. The only thing that's mandatory in the automobile world is mandatory liability to cover the stranger that you may hit. But in terms of you being hit by someone with inadequate coverage, you can buy what you wish to buy to cover yourself. And the third item, and it has been mentioned here by Mr. O'Quinn and by the Commissioner, is the unintended consequences of those on the margins, that if prices rise, and I think this affects more their market than State Farm's, but as the prices rise, I think folks may drop out of that and have no UM coverage. So the unintended consequences is, or may be, that there will be more folks without coverage in the first place. It is for that reason that we are concerned about it. We would not be dealing with an offset in that circumstance or an add, because there would be no UM coverage by those folks at all, and that is our concern. Finally, there's one concern about the timing of this, and that is the effective date right now. The subcommittee moved it to January 1, and we appreciate that, but in terms of rate filings, with this volume of rate filings, should this bill pass, there will be a backlog, and we would ask that should this bill pass, an effective date be moved out to July 1 of 2008 to give the Commissioner's Office time to address 600-plus rate filings at the same time. Those are our concerns. I'd be happy to answer any questions, Mr. Chairman.
All right, any questions from the committee? Yes, Mr. Levitas. This isn't really a question just for you. This would go to the small and large carriers alike. Obviously, you heard my questions about the disclosure card. Would you, and I know you can't speak for your colleagues, but speaking for State Farm, would you have an objection to not only having a form, the simple kind described by Commissioner Oxendine, that discloses in very clear blank terms what it is that this insurance does, how the coverage actually works, have the insured sign that, and that the agent sign underneath that they have explained the terms, and the customer says that the agent has explained these terms to me, the broker, however that works. Would you have an objection to having that as a separate, I'm not talking about all the disclosures, I'm talking about a separate card that has that information on it. Would you have an objection to that?
Representative Levitas, I think there is a form now that agents have to have folks sign if they elect to have no uninsured motorist coverage, or if they elect to have UM coverage less than their liability. They have to sign off on that now. So I think to the extent that a form exists, it exists now. What the Commissioner has referenced was an expanded version of a form. I think we would have no problem with that, with additional language that discloses that. I think one of the concerns generally is that once one, and I think it was Representative Abrams that expressed that, she maybe hadn't looked at her policy in 10 years, once one leaves their agent's office, they're not going to remember a whole lot about that, and they certainly won't remember it 2 or 3 years down the road.
Right. And I guess I would, and it's maybe a different underlying assumption. I question the assumption that most folks understand how UM coverage works and that they leave understanding that. My belief is, and this is anecdotal, I'm not in your business, I don't suppose to know as well, much less better than you do, what your customers do and don't understand. But if, as a layperson, and I'm just a simple chemical salesman, but as a layperson, if I buy $200,000 worth of something, my belief is that if I'm in an accident, I will be covered for $200,000 worth of that, irrespective of anybody else's anything. And I understand that's not the way it works, but I'm just suggesting that it's not quite that simple. My other question goes to the loss of customers, and I do understand what you're saying, that on the surface it would seem appealing to insurance agents if we can charge more for the policy it would make sense that we'd want it. Why are we against it? And again, not the brightest guy in the world, but I understand a little bit of supply and demand, and I understand that if you have a lower price, you're going to have a greater volume of business and generate perhaps overall funds, whereas if you have a higher charge for a premium, you're going to lose customers such as the ones you've identified. So my question is, have you looked at whether or not you would lose overall revenues if this goes into effect, or whether it would increase your revenues overall? Are you aware of any studies in your industry in states that have adopted statutes like this?
I am not. And just to clarify your comment about being in this business, I'm actually one of those lawyers work at a law firm, represent State Farm, so I don't do this day in and day out. But I don't think there's been an analysis, and frankly, they don't look at this from that perspective. Will they increase their customer base? Will they make more money, or will they make less money? These comments really are relative to the availability for the policyholders. We have the experience, and Senator Staten had referenced some numbers in surrounding states, and parts of those numbers came from State Farm, and those numbers would reflect where it's Alabama and South Carolina. The increase is a little more than 100%. For Southern General and others, it would probably be more than that.
Is there any other questions for Mr. Potter? Thank you very much.
Thank you, sir.
Appreciate you coming down today. What's the committee's will on this matter? All right. Well, they can be in the nature. Just comments? All right. Go ahead and make your comments.
Well, certainly I don't know the first thing about a whole lot of insurance, and I certainly would not want to be in the insurance committee now after listening to all this. And certainly after listening to Senator Staten talk about his $3 increase and everyone else that's testified about what the increases are going to be, the devil is always in the details when it comes down to purchasing any kind of insurance or anything else. I also believe in less government, and I think this is going to be a mandate, so therefore I cannot support this bill.
Thank you. All right. Is there? Yes.
Pass on bill.
Second. Is there any further discussion? All right, seeing none, all those in favor of Ducast's recommendation, raise your right hand. My substitute. All right, do pass. Thank you very much.
Signed up, we have lots of people. Some have already come off, it appears. Jim Collins, I think, is still here. Is it Etta Hawkins?
Yes.
Okay, thank you very much. And Clint Austin, I know, is here or was here. Yeah, okay. Jay Morgan, Ellen Williams, I know, is here, and Wendy and Matthew Van Hook. Mr. Van Hook here. All right, I think at the request, I'm sorry? Yeah, I was fixing to recognize him, saving the best for last. And the bill's sponsor is Senator Don Thomas, and we're honored to have you with us today. Is it my understanding that you're wanting Chairman Knox do your presentation? Yes. Okay, all right. We'll recognize you then for opening comments, Senator Thomas. Yeah, that's fine.
Thank you, Mr. Chairman. This is a very important bill that's been worked on for at least 2 years now, and I think it's pretty well perfected, and we would like for it to pass as the substitute ALC 33-2100S, and it's Senate Bill 205. And there's been a lot of attention given these articles in Business Week Online, the Wall Street Journal, New England Journal of Medicine, Parade magazine, on the increasing problem of fake drugs and counterfeit drugs. and it's worked into a multi-million-dollar profit for these people that are putting these drugs out. The bill itself concerns moving it from the manufacturer through the wholesaler or wholesalers to the final destination, and it makes sure that validation of that drug pedigree goes with it at every stop. And I'm going to say thank you for allowing me to come and bring the bill, and ask Chairman Knox to take it from here.
Before you step away, because I want to be very clear on your position, because of the great respect I have for you, and you know that. You have a sub that Chairman Knox has passed out here, and you've endorsed that sub.
I have endorsed that sub, and I don't endorse any amendments to it.
Okay. No other changes other than that sub?
That sub, right.
Okay. All right.
Thank you, Mr. Chairman.
Thank you, Senator Thomas. Thank you for being with us. And you can stay. I didn't mean that you had to leave. Okay. Chairman Knox.
Thank you, Mr. Chairman.
And you're speaking to LC 33-2100S?
That's correct.
Okay.
Thank you, Mr. Chairman, members of the committee. And Dr. Thomas asked me to help him with this bill today and work with him because he, like many of us, have a number of meetings to attend today, and he's also been working as a physician today, so he's even further behind today. He's been helping some of our folks who had some health problems.
By the way, I hate to interrupt you, but do we have any report on our colleague?
I do not. Maybe Dr. Thomas knows.
I don't have any official report, but I really feel like he's okay.
Okay.
He probably didn't have a heart attack. If he did, it was very light.
Okay, good. Okay, he's been in our thoughts this afternoon. I'm sorry, Chairman Knox. I just wanted to hear from our colleague there.
Yes, sir. I appreciate it. Thank you, Mr. Chairman. Mr. Chairman, if I could, let me just make some brief opening remarks about the bill, and then I'll try to discuss it in more detail and take any questions. Also with me is Clint Austin, who's worked very closely with Dr. Thomas on this bill. And this bill has actually been probably around a couple of years now, I suppose, that we've been working on this bill and trying to make sure that we focused in on the problem that we want to try to cure. SB 205 is designed to address the growing problem of drug counterfeiting. And I think y'all have a handout that I put in the asked to have put on your desk, and the bill, as I said, has been worked on for about 2 years in order to come up with a strong bill that will address the problem that has arisen in the distribution system of drugs, and we call it drug counterfeiting. Essentially, what this bill does is, I guess, the most succinct way I can describe it, since y'all are on the Judiciary Committee, y'all are somewhat familiar with the term chain of custody. And that's basically what this bill is trying to do with respect to transactions between certain wholesalers of drugs. It seems that there has developed in what was almost a problem that was almost non-existent 10 years ago. It's now a major cash industry, and that is drug counterfeiting. World Health Organization estimates that there's about 10% of the drugs moving in the world today are actually counterfeit drugs, and that they expect that number may as much as double over just the next few years. The National Association of Boards of Pharmacy say that there are millions of bottles of medication in the United States today that are fakes. The Parade magazine had a story recently noting that drug counterfeiting has taken the lives of Americans, and the perpetrators are walking off with billions of dollars in black market profits in this counterfeit drug market. And some of the problem with this is that not very many people know how drugs actually get to their pharmacies, and the process involves the movement of a drug from a manufacturer to a wholesaler and then to the pharmacy. That's what we call the normal distribution system, from the manufacturer through the wholesaler to the pharmacy. And that's accounts for about 90% of the drugs that are moved in that way. And we're not attempting to address or to involve ourselves in that process at all. What we are trying to do, though, is to address issues that arise in this, what's called the secondary wholesaler market, or as the Wall Street Journal refers to it, the gray market of drugs. And that's the market where individual wholesalers pass the drugs from one to another before they eventually arrive at some destination. And as it moves from wholesaler to wholesaler, there's no documentation as to where the drugs have been. So after a few of these exchanges, it becomes almost impossible to tell the origin of the drug and also to tell what the validity of the drug is. And so we don't have a good idea of whether the drug is safe, whether it's effective, or whether in fact it's a drug at all. And so this bill is attempting to address that by requiring what's called a pedigree, and that is where the wholesalers are required then to keep track and be able to verify where they got it from. That's essentially the thrust of the bill. Now, the bill is fairly long and somewhat complicated, but we're all used to seeing those kind of bills in this committee. The reason for it is that we've gone to some length to, number one, include all of the parties that are usually involved in these transactions and be sure that we don't intrude upon any legitimate transactions in the delivery system, while at the same time trying to identify, laser in, focus in on that so-called gray market where we know for a fact that criminal elements are working. Florida had a drug like this for several years, and it's had a substantial effect on decreasing some of the problems that we're talking about with respect to counterfeit drugs. You might, I suppose, if you thought about it this way, if you thought you were buying a diabetes drug or a blood pressure drug, and it turned out that it was a drug that was manufactured in, South America someplace, and was brought here repackaged by a wholesaler who's not a legitimate wholesaler, but really a criminal enterprise, and they were able to put that into the distribution system, deliver it to a drugstore, you take it home, and you think you're taking care of yourself. That could be a serious consequence for you. So this bill requires that we establish and have an extra level of documentation that's called a pedigree, so that we can tell where those drugs are coming from, who sold them, and who bought them, and how they arrived at the destination that they've come to. It doesn't ban wholesale transactions. It simply says that if you're not in the normal distribution system, that is from the manufacturer to the wholesaler to the drug to the pharmacy, that you need to be able to tell us where this drug came from and be able to document how you came to it. Some of the elements of this bill are supported by FDA reports on how we secure our nation's drug supply. In a report, FDA called for 50 states to pass the pedigree requirements and increase criminal penalties for counterfeiting, and this bill follows those recommendations. And actually, some form of this bill has passed in 17 states as of today, including, as I mentioned previously, Florida. The elements of the SB 205 that we're looking at have also been adopted as model legislation by ALEC, by the Council of State Governments, and by the Pharmaceutical Manufacturers Association and the National Association of Boards of Pharmacy. I'm going to stop there and see if anyone has any questions. I may have to call on my backup, Mr. Austin, to help us with technical questions, since he's been so heavily involved in that part of it. And there are some technical and complicated parts of this bill.
Okay, Chairman Franklin.
Thank you, Mr. Chairman. Is there anything in this bill that would criminalize or prohibit buying drugs online from somewhere, provided that those have their pedigree and whatnot?
There's nothing in the bill that would prevent. There's nothing in this bill, and that's why we've gone to some extent to to set up definitions and to describe this network that we're talking about, and make sure that we're not interfering with legitimate sales of drugs by legitimate entities. We're strictly looking for those entities that want to profit from unlawful criminal enterprises under the guise of a wholesale drug distributor.
Further questions of Chairman Knox? Further questions? Thank you, sir. You either did an excellent job or we don't understand anything about it.
All right, it could have been both of those, Mr. Chairman. Once in a while I've done a good job, you know. If I may, I would like to have reserved the right to close.
Do the closing? Okay. Sure. Jim Collins? Ms. Hawkins, you'll be on deck. I'm just taking everybody in the order in which they signed up.
Thank you, Mr. Chairman. I'm here on behalf of Healthcare Distribution Management Association with a basic thing. You had a Senate bill that had about 52 lines in a normal distribution channel. In the bill you have before you, it has 61 lines in a normal distribution channel. And there's a sub out there. It's LC 2929005S that manages to change that to 16 lines. Basically, it's a real simple amendment. It just cleans up the language. It makes it simpler. It goes back to the pharma model, and it's very technically simple. And that's really all I'm here to speak on that issue. We're in agreement with the bill. The bill is a good bill, but that language is just very convoluted, very cumbersome, and it would be a lot better if it was cleaned up.
Okay. Thank you, Jim.
I know the lateness of hour. I'm not going to stay here for long.
No, that's. Any questions of Mr. Collins, Representative Levitas?
I don't know if you can answer this, but I mean, why would the sponsors or authors of the bill go to all that trouble if they thought it could be handled in 60? I know Chairman Knox, one of the smartest guys I've met up here, and I know he wouldn't bring a bill to me if it wasn't absolutely necessary. So why would they do that?
I would absolutely agree with you about the chairman. I'm going to let the sponsor of the bill talk to that. But basically what's happened, I think there have been a lot of agreements and discussions about how to best do it. And you add this, and you add this, and you add this. And before long, you've got about a page and a half of lawyerese. And other lawyers have approached it. And you've got model legislation that can do it in 3 inches. It's just a cleaner, better bill, bottom line.
I'm sorry, Mr. Mayor, I have one quick follow-up.
Yes.
Do you have any objection? I know you're in support of the sub. Just suppose that they went with the longer sub. Do you have any problem with that? I understand you think it's more cumbersome, but are there any specific problems that you have with it, or just that it's a little more cumbersome?
The biggest problem has to do with the quality of the bill and the fact that it's just very confusing and it's just not as well written as it could be. The legislation could be better, and that's the main problem, is just cleaning up the language and making it stronger.
Thank you. Thank you, Mr. Chairman.
Mr. Collins, you know how much respect I have for you and enjoy your friendship, but is the motive here really to get a better grading composition?
Well, it's not a better grading composition. The bill as it's written is very, I guess, convoluted. I mean, when you look at it, it's got multiple things in it.
Well, it's not the first convoluted bill we've taken up this year, so.
That's true, but there's a way to do it better. And going back to the model language that everybody signed off on, including Pharma, Pfizer, all the major groups, and is in play in, I believe, 2 states right now, potentially to go to other states. So that's just moving it to more correct language.
Okay. Well, let me hang on one second. Chairman Knox or Dr. Thomas, is that just is there anything wrong with that?
Well, Mr. Chairman, as you well know, I'm not one to champion government interference, and part of the reason that this bill is longer perhaps than some people would like, you never have a perfect bill, and no one's completely happy with any bill. I think Dr. Thomas and the folks that have worked on this have done an excellent job of making sure that we're not interfering with the normal drug distribution system, that we're not interfering with, and we're not getting into any issues about, what do you call it, what's the, not brand name, what's the other thing? Generic drugs, or that sort of thing. And, it would be nice if we could, make everything that we need to have known about a subject boiled down to 2 words or 2 sentences. But, the shortest verse in the Bible is Jesus wept, and that's 2 words. And so, if the Bible can not do something in 1 word, probably it's not going to be within the ken of men to be able to make a a bill in this House that's going to be real short.
You want to jump in on this, Dr. Thomas?
Yes, I like the LC 33-2100S. I think it's the bill that we've worked on for so long, and I think it gives us security of the drugs, the fake drugs, and the pedigree goes with them. And we had everybody agreed on this at one point with the other manufacturer, the other pharmacy groups agreed on it. And it's just was this one amendment that came in, and we think the bill as it is written is the one that should pass. If some changes to be made in the future, it becomes legislation.
Okay, thank you. Any further questions of Mr. Collins? Do you have any further comments, Jim?
All I would say is,
sorry, Representative Bearden.
So you're saying that, am I good to go?
Yes.
I have to leave, but is this the, you're saying that the LC 292905S is the one that everyone signed off on to begin with?
it is exactly the same with the exceptions on page 2, beginning on line 17. It starts with normal distribution channel and goes down from line 17 to line 32.
And one quick follow-up.
Well, and that is in comparison to on the other LC version, the 33-2100S, where it begins on page 2, line 27, the same normal distribution channel language, continues to page 3, the entire page 3, and into page 4 to line 13. And rather than coming back and dealing with that at a later date while we're here, this is something that could be fixed.
And just a quick follow-up, if I may.
Sure.
You said everyone signed off on 2905. Are the ones that signed off on 2905, are they in opposition to 2100S?
No. In other words, this amendment here is not in opposition to the bill or the idea of the bill or the concepts behind the bill. It's just doing what we do with legislation. It's perfecting it and making it better.
It just takes out a lot of the verbiage and breaks
Yes.
it down to probably more easier.
Yes, and going to federally adopted model language.
Okay, thank you.
Further questions of Mr. Collins? Representative Abrams.
Yes, I was noticing on page. Sorry, let me get back. I'm actually comparing the two. For example, one of the distinctions I see between 2100S and 2905S on page 6 of 2100S, there's subsection L that deals with this sale, transfer, merger, or consolidation of pharmacies. And that language is not included in 2905S. Are there, so it's page 6 of 2100S and page 4.
Yeah, please. You don't mind, do you?
LC 33-2100S was the Senate version with a number of changes. LC 29-2905 is the Senate version, and the only change is the definition of normal.
I can answer exactly why that is. That language is on page 4 of 2905S. Basically, we saved 2 pages of bill. So you were looking on the wrong page. If you'll go to page 4, and you'll look under K, I believe, is going to be it. The sale and transfer from a realty. Is that the same one?
No, that's separate.
Okay. It should be an exact same duplicate. It should be in there. The only change is that addition.
It's not in here, and that's part of my concern. I don't understand it, or I wouldn't say don't understand it. It may be a more appropriate question for Mr. Knox. I mean, this actually removes that language. So okay, assuming 29 was first in time, 2100 adds language.
The different, LC 33 is a different attorney, and that bill is the Senate version with a number of changes.
Right. No.
The only change in 2905 is the definition.
My question is more of a substantive question. So the substance of why you would not include this provision.
Those are new changes that we had not seen. I just received this about 1 o'clock today. That was probably taken from the Senate version. I'm sorry, I didn't understand the question. This is the only change between LC 292905S and the Senate version should be those 12 lines, 17 through 32 on page 2.
And just to complete my question, I guess my question is, if you look at the language that's on page 6 in the NOx substitute,
Correct.
is there a reason to not include that language?
Not at all. I have the only language change I am at all advocating for or against is to just tighten up that normal distribution channel that would be on pages 2 of the NOx substitute. And I'm sorry I didn't understand your question earlier.
Final call for questions for Mr. Collins. Thank you, Jim.
Thank you, Mr. Chairman.
Etta Hawkins.
Good afternoon, Mr. Chairman and committee members. Thank you for the opportunity to speak. My name is Etta Hawkins, and I am a registered pharmacist. I am representing the Department of Community Health Medicaid Pharmacy Services Program. The department, we believe that whereas the bill's concept is admirable and well-intended, we do have some concerns of what we believe are unintended consequences. We believe that the bill will have a negative impact on our DCH pharmacy budget. We think that it will actually increase pharmacy costs. Our current generic utilization rate is right at between 58 and 60%. And we believe that this bill could very well prevent manufacturers of generic drugs from doing business, making a business decision, and such that they would be unable to continue doing business at the current level that they are in Georgia. That would be because they could very well not be able to afford to implement and activate the pedigree process, and as a result, generic drugs could very well not be available in the same quantities that they are. One of the cost-saving methods that we employ now is called a generic maximum allowable cost, a GMAC, where we allow an upper limit reimbursement on a drug. And we're only able to do that if there's a certain volume of generics available. Our fear and concern would be that in the absence of significant volume of generic manufacturers able to do business in Georgia, that we would not be able to MAC the same number of products that we currently do. So our concern is that this could very well decrease the availability of generic drugs here in Georgia. And that is the extent of my comment.
Thank you very much. Questions? Yes, Chairman Franklin.
You said you were with
the Georgia Department of Community Health Medicaid Division.
Is there anything that your department is doing to qualify or verify data before you put someone on the Medicaid rolls, as far as cross-matching income, say with the Department of Revenue? They might say their income is a certain amount on their application. Do you check their tax ID numbers and their addresses with the Department of Revenue or with motor vehicles to see, okay, they just bought a brand new Lexus or Bentley, and yet now they're on Medicaid? What do y'all do to save Medicaid costs so that when someone goes to the drive-through pharmacy, say at Kroger, in their brand new Bentley, and they pay for their prescription drugs with their Medicaid card? What do y'all do to cut down on you seem to be concerned about the cost of the program. What do you do to make sure that those who should not be on the program aren't on the program?
Unfortunately, I am not the eligibility subject matter expert. However, I do know that as a part of the screening process for application, just recently, I believe in 2006, that they began, as a part of the application process, began to cross-reference with some of the databases that show other income sources. So I do believe that currently now they're looking at more than just what one testifies to on paper, but they actually do some behind-the-scene data mining to determine if the person has other income.
Further questions of Ms. Hawkins? Any further questions?
Just let them know that that's actually taxed to DFACS under the Department of Human Resources. They actually determine eligibility. We administer the program. So it's really, they would probably be better to speak to that.
Okay. Thank you very much, Ms. Hawkins.
Okay, thank you.
Clint Austin. And Jay Morgan will be on deck.
First, Mr. Chairman and members of the committee, thank you for your time and attention to this matter. Here today on behalf of Pfizer, drug manufacturer. There's been some specific issues that were raised. We're kind of looking at the wrong end of the animal right now for Ken. Want to certainly come back to those and address those for the committee. Want to go back, if we can, to somewhat, in our view, put our eye on the ball. And the ball is this. There is a currently already large, and there is a growing problem with drug counterfeiting. Counterfeiting can mean a number of things. It can mean outright counterfeiting. It can mean what's called up-labeling. It can mean a number of different things, all of which boil down to when you put the pill in your mouth, you're not sure you're getting what your doctor said you were going to get. To give you a scale of how fast this problem has grown and where it is now, actually the day this bill passed in Senator Thomas's committee, where, by the way, the last two issues you heard were not raised, story ran in the AJC about prescription drug abuse has passed illicit drug use in the United States. In the United States alone, according to AJC, the abuse of painkillers, stimulants, tranquilizers, and other prescription medications has gone beyond, quote, practically all illicit drugs with the exception of cannabis. And the abuse of prescription drugs has spawned a lethal new trade in counterfeit painkillers, sedatives, and other medicines, potent enough to kill. Florida was referenced in the early stages of this. This has sort of been ground zero where this issue came to a head and where the problem was first addressed. The Florida investigative agency that headed up the effort that led to their law was called Operation Stone Cold Killer. People died from the use of counterfeit medicines. This is a real-world problem with real-world consequences. The article that was mentioned about that ran in Parade magazine with the discussion about millions of bottles of prescription drugs dispensed today could contain worthless filler. This quote was made in that story from Carmen Cazzoni, the executive director of the National Boards of Pharmacy. Quote, if the system becomes further compromised, it will get to the point where it's very difficult to fix. This could cripple the whole healthcare system. The media handout that you were given with stories from the Wall Street Journal, Business Week Online, the New England Journal of Medicine, the Newark Star Ledger, discuss different aspects or different examples of how this problem has occurred and that it is only expected to grow, not shrink. Frankly, you can make just about as much, if not more, money today selling counterfeit, quote-unquote, prescription drugs than you can selling traditional illicit drugs. That's why there's a movement towards it. And again, Florida was sort of ground zero for it, and it provides the example. I think we want to paint a picture again for what the problem is and how this bill addresses it. 90 to 95% of drugs move through what's called this normal distribution chain. Now, it's a little bit more complicated than that because distribution of drugs is not an ABC process, and that's going to get into why this definition is longer than anyone likes it to be. But 99% move that way. They move from a manufacturer to a wholesaler to a pharmacist or to a pharmacy that dispenses those drugs. This bill, let me make something clear, this bill does not touch those transactions. They won't affect those transactions because those transactions are very secure. They're not identified as a problem. This legislation acts on what are called secondary wholesale market transactions, where drugs pass through multiple wholesalers before they get to market. This bill doesn't ban that. It just says that if you're going to move a life-saving medicine that is not, it's not bite spare parts. It's a fragile product with very important biological and human ramifications. If you're going to move that drug through multiple wholesalers, you need to keep a document that will that will show where that drug has been, and those who handle it have to verify that where the pedigree says it's been is actually true. A couple examples of pedigrees here. We can pass around. One, I believe, is from Indiana. Correct me if I'm wrong. And the other's from Florida. And that brings us right into a couple of points about this bill. It's legislation both in this state and other states. This legislation passed the House of Representatives last year virtually unanimously as House Bill 907. That bill actually came out of House Health and Human Services. It went to the Senate. It passed Dr. Thomas's committee. Late concerns were brought to us. In keeping with the edict we've tried to obey throughout this process, which is a very open process, very consultative with all the stakeholders involved, we pulled the bill down, worked on it 9 months, and brought it back this year as Senate Bill 205. The bill passed the Senate unanimously. It passed Senate Health and Human Services Committee unanimously. The bill you're looking at was originally introduced as House Bill 907, and the language goes back to that from March 2005. This has been a 2-year-long process. We are not standing in front of you having not done our homework. I think that's a key point that goes to some of the thoughts that have been raised. It is a strong compromise. It involves work with wholesalers, both individuals and the association. Mr. Collins represents the Association for Wholesalers. Mr. Morgan represents the largest wholesaler in the world. Bo Moore from McKenna Long represents PSS, which is a wholesaler. They were involved in this. The Board of Pharmacy, the Pharmacy Association, the Drugs and Narcotics Agency, which works for the Board of Pharmacy and works under the Board of Pharmacy. Drug manufacturers, a wide gamut of folks. As any legislation that involves a large number of stakeholders, it is not perfect. It's not what any one entity would want. But what it does, and the reason we say keep our eye on the ball, is that it addresses the issue. The issue is serious and it needs forward movement. And after 2 years of study, we would submit a bill that has passed both the House and the Senate, just not in the same year, that it is probably time to move forward. Talking about the model language, and we want to get right into some of the objections that were raised before we came here. We ask that you reject the amendments that are offered in the form of the substitute. One problem is, I think has already been discovered, is that substitute does not incorporate even further changes that have been made since the Senate version in order to have buy-in from stakeholders. That amendment process has been 2 different draft subs since the Senate. That bill, that LC number, forgive me, I don't recall it, does not incorporate those changes. If it's the pleasure of the committee to incorporate the real intent of that sub, then certainly the committee can do that, but you need to be aware of that. You would need to amend the sub, or the LC 332100S with that language. You need to pull that out in order to preserve a number of other important things that are in this sub. But I want to talk about that language. Why are we, and it's true that our trade association favors that language, and Pfizer is the biggest member of PhRMA, which is our trade association. Why are we technically opposing that language? Not because we oppose the language, it's because it's very new. It's from a days-old process where the model language on this issue and the regulatory environment on this issue has been, I think at best, a moving target, is a good way to describe it. There's nothing wrong with the language of our bill. 15 different states have some version of this bill in enactment at the present time. We want the committee to feel sound and secure that you are dealing with good legislation and with good language, that those circuitous and lawyered up, we're in front of the Judiciary Committee, so we don't have a problem with lawyers. The 2-year-old process, in our view, where you have language that has buy-in from stakeholders, and why is it 52 and 61 lines? I think Representative Levitas got to this point, is because everybody has a little piece in there that's important to them. When you go to the encyclopedia, you don't pull out every book. You pull out the book you're looking for. Well, there's language in this that is important to somebody. And we feel like we have a commitment to those stakeholders, although we think that language is cleaner, that language, one is model language from D.C., it's not reflective of a Georgia environment, it's not been vetted with Georgia stakeholders. We're committed to, if it's possible, to vet that language after 2 years in the next 5 days. We've told Mr. Collins and others we'll do that. We'll do that and we'll get it in this bill, but we're not prepared to do that and to make clear that language is supported by our trade association and his trade association, but it's not supported by all the stakeholders in this process. It might be, but it needs to be vetted. It needs to be vetted in a Georgia context. So that's why we're telling you to oppose that language. Not because we have a problem with the language, but because we know for a fact it doesn't include things that stakeholders in this room have asked for. Made a lot of notes as we were going through that process. There might be indications that there's not been enough time spent on this bill. We would certainly quarrel with that suggestion given the 2-year-old nature of the bill. And the concept and the problem that the bill addresses is without a doubt serious. The concept is endorsed in broad terms by stakeholders across the spectrum, from ALEC to the National Boards of Pharmacy. And again, it's legislation that's passed this House. It survived a 3-hour vetting process in House committee last year, although not a committee as distinguished as this one. Is still a meaningful committee of this General Assembly. Chairman Thomas, as you know, is serious about the work he does, and you know he's serious about health care matters. And this bill, and the last point we would make about it, incorporates well over 100 changes. There has been no lack of input on this bill, no matter what can be said about it. One thing that cannot be said is that the bill lacks input. Briefly on the cost issue raised by our friends at the Department of Community Health. Today is the first time we've ever heard that issue raised. That's not to say it's not valid, but we would certainly, to the extent that we're prepared to address that issue, would say that we don't think it's a problem. The initial bill in Florida was very different from this bill. The initial bill in Florida pretty much caught everything, and there was a cost issue in that bill. This bill is targeted. There were lessons learned in Florida. It's going to affect 2 to 5% of drug transactions. 2 to 5%. In Georgia this year, federal agents and then a federal court in Savannah locked up a secondary wholesaler that came out of Florida for pilfering millions of dollars of counterfeit and stolen Medicaid drugs. Stolen Medicaid drugs. It is a small price to pay to make sure that the pill you're putting in your mouth is what you say it is, or what your doctor says it is, to pay the minuscule cost of implementing this legislation. In addition, the idea that it will affect the generic market is simply not occurred in practice. We own a generic drug company. We certainly would not craft a piece of legislation that would hurt such an integral part of our own operations. Probably thought may occur to you, why does Pfizer care about this so much beyond the obvious? We had 17 million Lipitor tablets counterfeited in the very recent past. There are a number of different instances, all the sort of anecdotes and horror stories that somebody like here who stand here could tell you about this. Won't regale you with too many stories other than to say this is a real and present problem, and that we believe that the time for continued work on language has ended and the time has come to implement something that will work. We sat with the Drugs and Narcotics Agency this morning because they will be the implementing agency on this bill. We told them from our posture to go back to changes. The only changes that we would want and that we would want to see implemented are changes that they request. Moving from this point out, other than the commitment we've given to Mr. Collins that if that language passes muster with the stakeholders, then we're more than glad to entertain it on the floor or some other conference committee or some other point in this process, but that to delay this bill further on the basis of late concerns or late language after 2 years' work is not something that we think or would find appropriate. At that point, we certainly want to yield to questions with one note, which is, as has been the nature of this bill throughout, there are 7 or 8 other technical changes and language that was omitted that we would want to submit to amend 2100S and at whatever time the chairman, in whatever way he might feel it appropriate to offer that.
Questions for the witness, Representative Bearden, and then Representative Byrd.
Quick question, just to make sure, you said about 95 to 95% of all drugs go through the normal distribution channel?
90 to 95%.
And it seems like the big tie-up between 2905 and 2100 is the definition of normal distribution channel to this smaller version to this much larger version, right?
Correct.
I know this committee's not real fond, and I'm not real fond of passing something when I've done heard at least twice today saying we can come back to fix it later if we need to. I think we work very diligently to make sure what passes out of here don't have to come back in future legislatures. And, Mr. Chairman, I know we got another meeting, and if it's totally up to Sheriff, if these two can maybe work out some common ground between now and that next meeting, it would make me feel better, so another legislative body don't have to fix it.
Mr. Chairman, can I address that point?
Sure.
The language of the current bill 2100S has been vetted by stakeholders. To this point, we have not heard a substantive objection to the language. Matter of fact, PSS, the wholesaler, specifically asked us to hold to that language because they have one of those things in there that addresses the way they do business. We felt that it was better to write a long definition that captures all the way that people do business so we don't hinder the market with simpler but perhaps less subtle language. When one additional definition or one change to an additional definition would keep them from being inappropriately captured in the pedigree requirement. That having crafted those agreements with the private businesses that implement this legislation so that their business is not inappropriately hindered, that we don't think the definition needs any changes. When we say we're glad to change this in the future if that proves to be the case, we're saying if there prove to be problems with implementation, we think the language is fine as is. And we would say that if you pass the language that has been submitted to you, we know people in this room, and I think they'll testify to it, who will tell you that language is problematic and it will need to be changed, unlike ours. Does that make a point? The longer language is actually protecting private business and not capturing private transactions that shouldn't be captured in this pedigree requirement. Does that make sense?
I understand that, and also understand the dangers of prescription drugs. For example, in my corporate career, I was getting more prescription drugs DUIs than I was alcohol DUIs.
Yes, sir.
But but the thing that concerns me was what I heard twice already was we can come back if there's a problem. I want to make sure if everyone's at the table. We're only talking about a couple more days anyway to make sure it's where it needs to be. Yeah, I don't think that's asking too much to make sure we are definitely sure this is correct and we don't have to come back in the future. And I don't think that's asking too much. It may be. I could be overruled any second now, but that's just my personal opinion.
Sure. Well, with humility, I'd suggest.
I'm not overruled. Just give me the word, Mr. Chairman.
Representative Byrd.
I want to be sure that I'm working off the right one. 2100S, is that correct?
Yes.
All right. On page 4, line 33, number 18, where it talks about repackaging.
33?
Yes, line 33, it's number 18 there.
Right.
Repackaging, does that mean that there's individuals that get drugs and they return them to some place like I return clothes to the department store? Or could you explain to me what repackaging, repackaging drugs?
It is a fairly standard practice in the business to take a larger shipment of drugs, to break it down and to repackage it into a smaller shipment or to a smaller, just a smaller shipment or smaller dose pack, or I think there's any number of terms on it, but that's probably the crude but simple way to describe it. And so that is, again, because the treatment of drugs and the handling of it is so important, we want to define every term. This is a point about repackaging in general. The definitions are the meat of this bill. You change a definition, you change this bill a lot. The operative section is only actually about this long. It's just the definition to make sure, again, that private transactions that shouldn't be included or not. But back to your point of repackaging, it's just breaking down larger shipments of drugs.
Sure.
And also in that same chart on line 35, why is it that pharmacists are excluded?
Pharmacists are not the threat to the to the safety of the drug transaction or the drug distribution market. There's very little evidence of pharmacists being a weak point in the drug distribution system. The overwhelming evidence, and FDA, by the way, the pedigree requirement was recommended by FDA that all states pass a pedigree requirement. In addition to the other folks that have been mentioned, to our knowledge, no one has ever really put the finger on pharmacists and said, you're a problem. Matter of fact, I would say the two entities in the drug system that have the most vested interest in ensuring that the product is safe and what it purports to be are pharmacists and manufacturers. Sometimes we're at odds on issues. We are, in concept at least, together on this issue.
Yes. Absolutely.
Well, I certainly don't know if there's been any pharmacists charged for stealing drugs or giving wrong drugs. I certainly do know that they switch drugs, on occasion from generic and brand name to generic. So we do.
Don't talk about this much. We're getting along with our pharmacist friends right now. Ellen's going to get me if we talk about this too much.
Well, so I'm just making a statement that
Yes, ma'am.
back to other things, a pharmacist. And lastly,
We're glad to put therapeutic substitution in the definition of counterfeiting, but that's another fight for another day. That's it.
when drugs are repackaged, is there any kind of repackaging money that is made out of this? I mean, so if it moves from a pharmacist and they repackages it and sends it out to someplace else, are there costs? Are they collecting money for repackaging?
Yes. Yeah, they are. The wholesalers are those involved in the repackaging. They're
Those who are repackaging.
yes. Yeah, I mean and there is a certain wholesalers provide a valid and important service, and nothing we want to say should be construed as disparaging wholesalers in general, or even the vast majority of wholesaler transactions, because the market is complex, it's fast moving, and wholesalers serve an invaluable role. But to give you a scale on this problem, the secondary wholesale market in Florida, there were 3 or 4 wholesalers handled 90-95% of the transactions, but there were 600 licensed wholesalers handling just sort of very small niches of the market, making it very easy to penetrate the system. What happened was a Colombian drug guy set him up a secondary wholesaler market. He faked some Lipitor down in a Colombian jungle, sold it to another wholesaler as a wholesaler himself, and it ended up in a legitimate wholesaler operation, in a legitimate pharmacy, and then in someone's medicine cabinet. But yeah, everybody makes money in the process, but it's legitimate and it's for a good business purpose.
Thank you.
Yes, ma'am.
Further questions of Mr. Austin? Representative Levitas?
Be here without it. I don't know, Mr. Chairman, what the pleasure of the committee chair might be, much less the will of the committee. If it is to postpone consideration, then I can get together with the folks afterwards to go over some what I think are friendly amendments. But I do have 1 or 2 substantive questions that I'd like to ask now.
Ask your substantive questions.
The substantive questions go to the page 9, the criminal provisions in 26-4-205. This is a question on subsection A. It appears to me by reading that if you violated, no matter how many violations you had of the statute, it looks like it would be just a $10,000 fine, and I would assume that was an intention to have $10,000 for each violation of the subsection. That's just a question out there. You don't even have to respond to it. It's just for further consideration. Then in subsection B, there's a punishment of imprisonment of not more than 15 years, but I don't see any indication whether it's a felony or obviously it would be up to a felony because you got more than a year there, but there's no minimum sentence of a year or more, and there's no indication whether it's a felony. And I don't know whether that's intentional or not, but it's certainly confusing to me compared to how other criminal statutes are written in the state of Georgia.
The language that's included here to respond is some of that nefarious model language that's been discussed elsewhere. It is enacted in some number of states. To my knowledge, there has not been a problem with enforcement, but that's not to say that you don't raise important questions. And if there's quick language that satisfies that, categorizing it as a misdemeanor it's not a problematic to us at all.
It's just a question out there. It's not a motion, not anything other than something for consideration.
And to go to this point of postponement, if I can, we are at the end of the session, and there is that great weaning out process which occurs in that little committee called Rules. And a delay of 2 days is crucial at this point. We're under make no assumptions that because this bill cleared the House last year that it'll automatically do so this year. And considering the large amount of work that's gone into this, and considering that while it seems simple to put a shorter definition in, that seems to actually simplify the bill. It'll actually complicate the bill because, again, I think the chain drug folks will have serious issues with that. We know that there's language that the Georgia Pharmacy Association asked for about pharmacy co-ops that's not included. Perhaps that can all be fixed quickly, but we would prefer not to see us delayed entering the rules process with all the work that's gone into the bill, while we can be working on those issues while the bill moves, in other words. And we've given that commitment, and we think that the amount of work we put into this bill will demonstrate that we mean that we're not, those are not hollow words.
Chairman Knox, did you want to be heard?
I'm going to pass on the issue.
Okay. Further questions for Mr. Austin? Representative Setzler.
I don't know if it's in order of purpose, I'd like to be recognized for information. Leave that to the discretion of the chair.
Further questions for Mr. Austin? Thank you, Mr. Austin.
Thank you, Mr. Chairman, members of the committee.
Mr. Morgan had scratched off, and Ellen Williams is up.
Thank you, Mr. Chairman. My name is Ellen Williams, and I'm here today representing the Georgia Pharmacy Association, and want to applaud the intent of the authors and the work of Clint Austin. We have worked very well together and very hard over the last month or so to try to perfect language. We got the most recent draft of this language at 11 o'clock this morning. We're here while we support pedigree bills in concept. We do have an issue with the fact that we've just gotten the language, and as Clint pointed out, if you change just one little piece of the definition, it dramatically changes this bill. And so we would ask that, in agreement with Representative Bearden's motion, that it be laid over for a couple of days so that we can work on it and actually have time to review the language, because the Pharmacy Association covers all pharmacists, which means you're talking everything from hospital pharmacists to nuclear pharmacists to chain pharmacists to independent community pharmacists. So a hospital pharmacist may have a totally different viewpoint and concern about something that a community pharmacist has. So it takes us a little bit longer to review the language. And since we got our last change, or our first copy of the latest version today, we'd ask that we be given a little bit more time to try to work out any differences we may have.
Thank you, Ms. Williams. Questions for Ms. Williams? Questions for Ms. Williams? Thank you very much.
Thank you, Representative Byrd.
Wendy Clifton.
Thank you, Mr. Chairman, members of the committee. I come before you today representing the Georgia Society of Health System Pharmacists, and that is a subset of GPHA. They are the hospital pharmacists. And we recognize, as GPHA does, and support the concept of pedigrees as they protect patients from counterfeit drugs. There's no question about that. Our number one priority is patient safety. We want to commend the proponents, in particular Dr. Thomas and Mr. Austin, for all the work that they put into this and work with the interested parties. The one thing that I just want to bring to your attention that's been interesting as I've sat and listened to the presentations made by the proponents of the bill is that the intention of this legislation is to create pedigrees for secondary wholesalers. But what's interesting about that is that the term secondary wholesalers is nowhere in this bill. There's no definition of what a secondary wholesaler is, but yet that's what we're attempting to establish pedigrees for. And so the way that this bill is crafted and what we just have a practice issue. Our practice issue is when a pharmacist reads this, there's going to be an awful lot of confusion, as it was when you sat and read this, as to what this bill means and what this bill does. If this bill is really intended for pedigrees to be established for secondary wholesalers, then that's what it should say. It should very simply say the definition of what a secondary wholesaler is, and then that they are required to establish pedigrees. The fact that we don't have a position one way or the other about the definition as it exists right now for the term norm or distribution channel. We understand that the intent of that language right here is completely and utterly exclusionary. Everything that's in there is what this bill does not cover. That's really unusual to establish public policy around everything that is not included. It should be, the legislation should be focused around what is this bill intended to do. And if we are here to intend to pedigree secondary wholesalers, which Chairman Knox mentioned as well as Mr. Austin, then our position is we want this to be simple enough so that when wholesalers and manufacturers, and for that matter pharmacists, read this, they know what it means. And that's simply the point that we wanted to raise today.
Okay. Questions for Ms. Clifton? Questions from Ms. Clifton? Thank you very much.
Thank you, Mr. Chairman.
Mr. Van Hook is our final witness. Mine don't.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to speak. My name is Matthew Van Hook. I'm with the law firm of Engel and Novid in Washington, D.C., a small food and drug law firm. We're counsel to PhRMA, the Trade Association for the Research-Based Pharmaceutical Industry, the manufacturers and companies that discover the drugs and manufacture them. I'm here today because we very much, PhRMA, the industry, very much supports the intent behind SB 205. As described by many of the previous witnesses, there's a growing problem with counterfeit drugs. If I may just briefly describe the roots of how the U.S. Congress first dealt with this and how Georgia and other states are trying to deal with this challenge. In the mid-1980s, Congress had a series of oversight hearings on the challenge of counterfeit drugs. It was a problem back then. And at that time, the Federal Prescription Drug Marketing Act was passed with two mechanisms to address the kind of problems that we're seeing today, except they've even gotten worse. One mechanism was to have a pedigree requirement to track and trace a chain of custody, a piece of paper that showed the chain of custody of a drug from a manufacturer through to the pharmacy. The idea being that when you get your drug here in your pharmacy in Atlanta, if it's required to have a pedigree, you can see where it came from and whose hands it was in. The other approach to bring safety to the system was to have minimum wholesaler licensing requirements. These are federal requirements for each state. States are required to meet minimum federal standards for, if you're a wholesaler, who are you? Do you have a criminal background? What kind of facilities do you have and standards for handling drugs? Fast forward 20 years, we've got increasing challenges from counterfeit. States like Georgia have been making very welcome efforts to come up with legislation like this to tighten up the system. But I have to tell you, while we support the intent of this bill, there are serious problems here that require extensive amendments before PhRMA can support it passage. Other model legislation, PhRMA has national model legislation, and the National Association of Boards of Pharmacy has model legislation. That model legislation addresses both of those columns. It has strengthening of pedigree, as this bill does, and it also has strengthening of wholesaler licensing, which this bill does not address. So I just wanted to point out it would be helpful to also tighten up wholesaler licensing. But to focus on the pedigree aspects here, if I can simplify this vision for you of where we have concerns. There are federal minimum requirements for pedigree. The legislation that states like Georgia are passing, the intent of it is to have tighter requirements to at least satisfy minimum federal requirements, and in other respects to tighten it up even more so that the riskier wholesale distributions are pedigreed so that you can see where the drugs came from and how they got into your pharmacy. Specifics. In this bill, I'm afraid, perhaps because there was too much accommodation for differing views, some of the definitions in here allow distributions that would violate federal law without having a pedigree. Federal law requires that unless you're the manufacturer or a manufacturer's authorized distributor of record, you must have a pedigree. That's the minimum federal floor. Now, one thing that's happened, there was a discussion earlier, I think Mr. Austin talked about how for the last 2 years there have been good efforts here to develop legislation. This is a terribly complicated area. At the end of last year, at the end of 2006, FDA finally issued its pedigree regulations, its final pedigree regulations, and they also issued guidance that gave clarity about exactly what those minimum federal requirements are. So folks in good faith were coming up with, crafting legislation, and this is one example. But unless the legislation meets that federal minimum, I'm afraid it could be an effort that will require you to come right back to the drawing board again to try to fix it. So we would urge that it be fixed now. The minimum has got to be that authorized distributor of record. If you're not an authorized distributor of record, you should be passing pedigree. The notion in the bill of a normal distribution channel, PhRMA very strongly supports that. It's that notion that allows a tightening of requirements beyond federal. If you look at the Florida State Attorney General's statewide grand jury report on this counterfeit problem, and they faced a terrible situation situation in Florida. They documented a situation involving a so-called federal loophole. That loophole says if an authorized distributor of record, and the example they used in the report was goes to an airport and buys drugs out of someone's trunk, if that authorized distributor of record turns around and sells it to a pharmacy here in Atlanta, no pedigree is required because it's an authorized distributor of record. So one of the key reforms here, and the reason for having a normal distribution channel definition, is to identify which authorized distributors of record should be passing pedigree as well, because under federal law, they never have to. So that definition is very important, and we would urge that that definition needs attention. And there are other aspects of the bill that come short of federal law. Notably, I have to tell you, I'm representing manufacturers. The bill excludes manufacturers from the definition of wholesaler. And under federal law, manufacturers, when they distribute drugs, are wholesalers, and manufacturers have to be subject to many of the same rules. And pharma, in our own model legislation, provides for licensing of manufacturers as wholesalers when they engage in wholesale distribution. So that's one example of where we think some more attention needs to be paid to get this right. Again, I want to strongly support the effort that's going on here. This requires such attention from folks that work on drafting this legislation and trying to get it right. It's a terribly great challenge, but it's worth the effort. If you can just see, as a previous witness testified, there's as much money to be made in counterfeit drugs as there is in narcotics. And it's been said that a benefit of it, a reason to go into it, is that you're less likely to get shot by your partners in the crime. It's a safer crime to do. So we need to make that, we need to tighten up the system more than we already have, and we need to increase the penalties. So we very much support those goals of this legislation.
Thank you very much. Questions from Mr. Van Hook. Representative Setzler.
Mr. Chairman. Mr. Van Hook, given your understanding of Georgia law that deals in this realm, and given what's presented in LC 332100S, would you say that 332100S loosens Georgia law with respect to controlling pedigree, or tightens it?
In many respects, it would tighten it, but in other respects, it would. The way it's written with such specificity, it would cast a spotlight on loopholes that would encourage people to distribute drugs without pedigree.
Does 2100S in any way loosen and open up current law?
The challenge right now is that Georgia law and regulations don't have the specificity about this. One of the previous witnesses said, can we identify where what is the rationale? Where do you need to pass pedigree? Efforts like SB 205 are aimed at giving that specificity. I think just one of the challenges is that until the end of last year, federal law was lacking in specificity, and states like Georgia have also lacked specificity. I think that's part of the reason why this kind of legislation is very timely.
So really the heart of my question is, given the complexity of the issues that you spoke to, and I think have been made clear here in this discussion, as I read 2100S, it's a step towards tightening pedigree, and is a step in the right direction. I would certainly submit to you somewhere there might be a hole that would need to be closed in the future. But as I read 2100S, it's a step towards tightening pedigree, and is therefore a step in the right direction. I think we can always highlight areas where we could do better, but I would submit that 2100S would be a good step for us to take. If you've got some direct examples of where this hurts things and loosens things, I'd like to share this.
With all due respect, I do. The list of exceptions from in the normal distribution channel definition in the bill now, it has, I think, multiple scenarios where if you're in one of those scenarios, you don't have to pass pedigree. One of the main areas of exception under federal law, and it would be appropriate to be in Georgia law, is if you're a chain pharmacy warehouse receiving drugs and distributing them to your own intracompany pharmacy. Under federal law, intracompany distributions are not considered a wholesale distribution. It's low risk. There's no need to pedigree that. This bill has two specific scenarios that appear to intend to address that kind of a scenario. later down in the list, there are 2 additional scenarios involving chain pharmacy warehouses. The language is different, and it appears to allow chain pharmacy warehouses to engage in what appears to be wholesale distribution without pedigree. And again, under federal law, if you're not an authorized distributor of record, you've got to pass pedigree. So either of those scenarios, why there would be duplicative scenarios is beyond me. If they're not duplicative, they're getting into areas that violate federal law. So that's 2 examples right there. There are others in that list. Third-party logistics providers, they're wholesalers. They've got to be authorized distributors. Manufacturers, exclusive distributors, if they don't qualify as authorized distributors, they've got to pass pedigree. The return issue is very complicated. This bill appears to allow returns back to the manufacturer of recalled and outdated drugs, for example. That's been one of the big entry points for counterfeit and adulterated drugs, is return drugs that are outdated. If you saw The Sopranos this last Sunday, the plot involved the crime family in The Sopranos buying 20,000 doses of Fosamax from some gangsters. Well, where are they going to unload that Fosamax? How are they going to make money out of it? They're going to inject that into the United States distribution system, so it ends up in someone's pharmacy shelf. So all of these little entry points for outdated, adulterated, and counterfeit drugs, we're trying to close. A lot of these scenarios, I'm afraid, in the bill here have holes that are contrary to federal law and should be closed anyway.
Further questions for Mr. Van Hook? Representative Byrd.
Yes. Did I understand that you came here from Washington, D.C.?
Yes, I did.
Now, do you file pieces of legislation like this around the states?
Yeah, I do, and I've testified in other states.
And will you specifically call for this piece of legislation?
Yes, PhRMA has representatives here who have been following this, and I was asked to come down today because I follow this kind of legislation, so I'm very familiar with the model legislation and efforts by other states.
Yeah, follow?
Sure.
And I think I understood you to say that you just recently came up with the definition of pedigree.
Well, no, there's been a long-standing model language that's very similar between PhRMA and the National Association of Boards of Pharmacy. It differs in pertinent respects. The definition of, for example, normal distribution channel, there have been efforts to come into agreement with other stakeholder groups. The basic definition that PhRMA has been very consistent. We've come up recently with some. I've not seen it in black and white, but it sounds like the substitute amendment is very much like language which has been recently adopted by PhRMA with other stakeholder involvement. But the essence of it is non-changed. The substance of it is unchanged in the last year or so.
Thank you.
Further questions for Mr. Van Hook? Thank you very much, Mr. Van Hook.
Thank you.
Let's see, where are we? Mr. Austin, did you want to have the closing word, or did you want to give it to Chairman Knox?
I'd be glad for him to respond to that, but if I could just make a comment, maybe even a question, I'd be glad to
Sure.
do that. This is the first that I've heard about this concern from Washington, D.C. 2 years this has been in the process, and this is the first that we know about it. And I'm a little bit surprised that with all the stakeholders involved in this, with all their pretty high-priced lawyers and legislative liaison folks and so on, that none of those people, maybe it's just because we're so benighted here in Georgia, but none of those people know what federal law is in regard to this matter, apparently. I'm going to submit to you, I'm not sure that that's correct, but in any event, it's first that we've heard of it, and so I'm a little surprised by it.
Mr. Chairman, I'll make this very quick.
Please.
The issue of federal law is a disputed. Matter of fact, I hate to put my own association on the spot, but kind of feel like they put us on the spot. This is a statement from them endorsing this bill last year. This language you're looking at, 90% last year. They endorsed this bill in the Senate. They're not now. I'm assuming there's a good reason for that. But federal law has been a moving target. The 1988 law is mentioned. It took 19 years for the Food and Drug Administration to issue regulations on 1988 law. Not 15
to helping with that. But you got a chicken and egg problem. You need something to hook. You can't go in and lobby for money for something that, for the enforcement of which doesn't exist. And we think that, again, this disputed point about federal law and regulation is something that should not hold this bill up. And again, Farmer in good conscience endorsed this bill last year. They endorsed it a few weeks ago. They can't now. We don't dispute that. But again, this is model legislation of the D.C. and disputed federal law, and it's something that shouldn't hold this bill up for progress again at this late stage when a 2-day delay could kill the bill.
Representative Byrd.
Nope, that's all right. And now you're telling us that there's going to be a fiscal note to this?
No fiscal note. This bill is not effective because it's an enforcement bill. It's not effective. This is in the bill and has been since the beginning until funds are appropriated for the enforcement of the bill. That's been in here since it's passed both bodies, the General Assembly and all the committees mentioned. Rick Allen, who's head of Drugs and Narcotics Agency, has said he's going to need help on this. I'm very careful to not represent someone coming or someone who's not here. But I think I'm on safe ground to say he agrees there's a problem here. He agrees that this could be a tool that could help in the enforcement of that problem. He testified to that fact in House Committee last year, so I don't feel like I'm on a limb to say that. So the fiscal impact of this bill will come next year, but we can't go ask for money to enforce something that doesn't exist. So we need to get this moving. And after 100-something changes, say enough changes, let's get something on the books. And if it's can be implemented in other states, it can be implemented.
Chairman Franklin.
I just wanted to make a comment of concern, not against the bill, but against some of the comments that were made against the substitute that Dr. Thomas and Chairman Knox presented to us. We heard from one group that they, the earliest that this substitute was available for them to look at was at 11 this morning, and therefore they did not have time to even make a comment on it. We heard from another group who sent their lawyer from Washington after this thing came out. And so we had someone who was not even registered in our state as a lobbyist lobbying before this committee. And I concur with Mr. Austin that it's time to move forward.
Further questions from members of the committee? Representative Setzler. Sorry. Thank you, Mr. Austin. Do you have anything further? Chairman Knox.
Nothing further. Thank you.
Senator Thomas.
Well, just very briefly, it's a huge problem, counterfeit drugs, and they're killing people. People are not getting medicine. Whether it's Lipitor or their high blood pressure, they're not getting the medicines that they think they're getting. And this is a step in the right direction, and we've been working on it for 2 years, so I think it's wise to pass the bill.
Anything further? Chair intends to see what the will of this committee is. Any further questions or comments on the bill? You had your hand up earlier.
Mr. Chairman, I'd like to make a motion that Senate Bill 205, LC version 33-2100S, do pass.
Second.
We have a motion that Senate Bill 205 be given a due pass recommendation by version 21 LC 2100S. Can't remember all the numbers. LC 33-2100S. Is there discussion on the motion? Representative Bearden.
I'd like to make a substitute motion.
Now's the time.
I'd like to make a substitute motion. We postpone this till Monday. The reason is we've heard from the people that represent the lobbyists. They just the lobbyists that represent the pharmacists who said they just got this at 11 o'clock today. I don't think 2 days kills this bill if we move this thing out on Monday, but gives ample time for them to make sure this legislation is where it needs to be and get with the pharmacists that we also represent. Yes, this is a bad problem. I support the bill and the concept. I want to make sure it's right, though, before we pass it. I want to make sure everyone's on the same page. especially the many pharmacists I have in my district, I like for them to be aware or touch base with. So I would ask that we postpone this till Monday. I don't know if I need to do that as a form as a table, because I don't want to put it on the table, but yet just postpone it until the Monday meeting.
I'll entertain a motion to postpone if there's a second, but I haven't.
Okay.
I'm sorry?
Second.
All right, we have a substitute motion that we postpone further consideration on Senate Bill 205 until Monday. Is there discussion on the substitute motion? Representative Setzer.
I'd like to thank Secretary Bearden. He and I have talked about this some, and I'm a fierce defender of this committee and our attention to detail. I think my concern, I think, is somewhat similar to Chairman Franklin's. It's my belief that this bill advances the cause of tightening up the system. I don't believe this bill harms anything, and I submit things might be able to be made better in the future. But I think this is still a significant step in the right direction that I do believe needs to be acted on day 35. So I would think that's really my purpose for opposing particular motion.
Okay. Further discussion on the substitute motion.
I do have one.
Representative Levitas.
I'm likely to support, since I seconded it, Vice Chairman's or Secretary Bearden's motion, but I would caution those in the crowd that if no substantive work has been done to work very closely with the senator and the chairman of the subcommittee by then, and there isn't substantive movement, I would support his bill and I would move to pass. So I would suggest that if Secretary Bearden's motion is successful, that some significant efforts be made to work with the chairman and with the senator to get things moving and get this bill cleaned up, so that if you do want it really passed, we can get it through rules quickly and cleanly.
Further discussion? Hearing none, all in favor of the motion to postpone consideration of this bill until Monday, April the 16th, when we next meet, please indicate by raising your right hand. All opposed to the motion to postpone? The motion has failed. That takes us back to the main motion, which was a motion by Representative Setzler, seconded by Chairman Franklin, to give a due pass recommendation to the bill. Is there any further discussion before we vote? Hearing none. All in favor of giving a due pass recommendation to Senate Bill 205 by version LC 33-2100S, indicate by raising your right hand. All opposed?
Don't want to lose twice in a row.
Bill be sent to the Rules Committee. For the members of the committee, I am planning one additional meeting Monday afternoon. Time to be determined. Will not be as long as today. See you in the morning.